I'd like to just welcome you from our VUB and Brussels Privacy Forum side to this symposium. This is actually the fourth edition of our symposium, which is quite a thing when I think it seems just like yesterday when we started it. But we've been able to run now 4 editions of this. Now, of course, this is the first time we've had to do it virtually. In past years, we've done it in Brussels on site, and I hope that next year we'll be able at least to do it maybe as a hybrid or maybe a purely on-site event. Our aim here is to look at current topics in privacy from an objective, scientific, but also policy-oriented perspective, and to really do a deep dive into them and try to illuminate them without taking a particular side or having any particular agenda. So we're very happy that all of you could be here today. I think we've chosen a very relevant topic this time, which is scientific research under the GDPR, something that's very current and very interesting to all of us. I'd like to thank very much the FPF for all the work they've done in organizing this, and as always have been great to collaborate with. I'd also like to thank specifically 2 people, Gianclaudio Malgieri and Gabriella Fortuna, who have really done a lot of the heavy lifting, I think, on the substance and putting the panels together, and you'll be hearing from them, I think, later on. And in particular, also, many thanks to our friends at FPF, again, for all the great work they've done. So I'm really looking forward to this. I hope you all will enjoy it, and we'll have some good discussion. And with that, I'll turn the floor over to Jules.
Thanks so much, Chris, and thanks to Gian, Claudio, and to Gabriella for the work, and you'll hear a lot from them as they lead and moderate. You know, I wonder sometimes why the hard question that we take on today isn't one of the maybe dominant ones that we see debated when you see press coverage or discussion or thinking about some of the challenging issues in data protection. Obviously, others, for a lot of reasons, you know, grab the headlines. But when you sit and think deeply, this is one that really is one of the most central problems and opportunities to define our morals and ethics and values in society. We see the value of data for research, for healthcare. It took a pandemic perhaps to, you know, kick the issue to the forefront for many, but I think many of you who've been thinking about this for a long time see the many mini crises or the many long-term opportunities for societal advance that come when data is carefully thought through and analyzed, and the new methods today, whether it was big data some years ago or whether it's machine learning and AI today, are only powering that. But they're also making these challenges more and more difficult because we're looking at data that companies hold. We're looking at data that is special category data, that's sensitive data. And so we thought quite timely to take a good look. How is GDPR, how are regulatory regimes helping us shape the protections for rights and freedoms that we know it is intended to do? In many ways, it's working well, and perhaps we hear from folks who want to debate some of the challenges or the areas where careful thinking can structure the protections in the way that we want for a moral and ethical society. So super delighted. Let me give just a couple of pieces of housekeeping before I turn to our opening speakers. First, of course, thank you to the sponsors, Big ID and TomTom. It always takes resources to put on timely and important events. We owe you the coffee and the lunch that is usually part of this and is sometimes the best part, where we have great informal discussions. So a rain check to you all for that cup of coffee and that bite. For those in the broader audience, please do use the chat and the Q&A. We are monitoring them, and our moderators will look and seek to pull out some of the questions. So please do engage. We look forward. We have some phenomenal people in the audience who, in the ideal world, would also be on the panels, and we want to take advantage of your participation. Since that hallway chat isn't going to happen, let's have it here, and we'll pull in those that we can. Chris and I were just taking quick stock. This we think is the fourth annual, so perhaps for five, we'll look to your input for what is really the key topic. We started out with AI, we did the identification, we did last year the intersection of data protection and competition. So these have all been timely and sort of at the right at the midst or the beginning of some of the really important debates. And I'm optimistic that we will be adding to the discussion here as well. We've always been pleased that we've been able to pull together a real interdisciplinary audience. There's probably no issue so much as research that really calls for that interdisciplinary discussion. We've got academic researchers, we've got government researchers, we've got obviously the corporate sector, and so, and of course, regulators and policymakers. So really delighted that the audience spans those funnels. Okay, without further ado then, not only thank you, Chris and the Brussels Privacy Hub and VUB team, but a very big thank you to Malte Breyer-Katzenberg from DG Connect, the European Commission, and Cornelia Kudera, Senior Director of EU Government Affairs, AI, Privacy, and Digital Policies at Microsoft. They will help us address some of the changes that the European Commission intends to bring to data sharing and to innovation policy, and of course, how those proposals will work with the GDPR and its comprehensive rules. So without further ado, let me turn the microphone over to Malte and to Cornelia. And first, Malte Breyer-Katzenberger, Team Leader, EU Policies on Data Policy and the Innovation Unit of DG Connect at the Commission. We're honored that you could join us, and so timely, given that you've been playing an important role on the Data Governance Act. Thank you. The floor is yours.
No, thanks very much, and I hope that works well. Otherwise, please interrupt. Broadband is not always on my side. So thank you. It's a really great pleasure to be here in this forum. It's my first time, so I'm really honored to be chosen to participate here. As you say, the Data Governance Act that was adopted last week is a first under the data strategy, and it tries to unlock voluntary data sharing. I should really insist this is about bringing out the tools, the means, the processes, the intermediaries possible that would facilitate that more data would be usable, but in a way that is controllable by those to who the data pertain. You have noticed that we use a language that spans data subjects, or includes data subjects and also corporate data holders. And when we speak about corporate data holders, they hold obviously not only personal data, and we're certainly thinking about the interconnection of machines and factories in the Internet of Things, and which then also brings, in my view, important questions of data control, data sovereignty, if you want, data privacy, and what means can you still use. So the future of the data economy is likely to be very decentralized. So we have to bring many more the algorithm to the data, enable federated ways of learning, machine learning as well. But I think we're not yet there for the protocols. My top picks another preliminary remark. We did this proposal evidently in close cooperation with the colleagues in the DG Justice in the relevant units dealing with data protection. And the ambition is not to reopen any discussion under the GDPR or to even try to modify it in any means. So this is, I'd say, builds absolutely on the acquis and tries to maybe add elements that would make the exercise of rights in the GDPR and the enforcement or the processing and complying with GDPR a little bit more effective. And here's maybe my top 3 picks on that front. So for the public sector, we say there are indeed important data sets that the public sector has that could be useful for machine learning. And we're specifically thinking about data that relate to health of people. There's a lot of scientific advantages out of that. And the question is now really in a very controlled manner, how could that happen? We have the examples of the French Health Data Hub. We have the FinData data permit authority in Finland. And we have also attempts in Germany to now bring out more what they call a Forschungsdatenzentrum, so research data environments, where data held in large national databases could be processed and then facilitated. And here, the key thing is that we want a certain investment from the public sector to do anonymization right. So we suggest that member states set up dedicated bodies, either centrally or regionally or on a sector by sector basis, that can help any public sector body, and that could be the public hospitals, but also other bodies, to do anonymization right and targeted to the needs of the user. So we're bridging that gap between preserving information value and making sure that rights under the GDPR are preserved, so that information privacy is guaranteed. And the second element in this first batch is, for me, that we bring also the notion of access facilities or secure processing environments to the field of the public sector in Europe, so that and the public sector can have supervised facilities that it runs itself, where a researcher or an innovator can come and say, okay, I don't want to see actually the data. I just want to calculate a few derivative indicators on the data, and please supervise me as I'm doing so. I'm actually interested in the content of the database, but I would really like to see a certain patterns, correlations, or even possibly train an algorithm. This is what we try to set up in the public sector and encourage the member states to do so. My second pick, obviously, is what we have discussed under many names, the personal information management services or the personal data stores. There's many names given to them. I don't think there's, I'm not really looking into finding distinctions between those, but that we find new services on the market where individuals could turn to and exercise then the rights under the GDPR. On a related note, I mean, you probably have noticed that the CNIL in France is consulting even on delegating the exercise of your rights to such a neutral or to such a third party. I'm not sure this is really something that is happening anywhere else. Maybe there's also a question for discussion here whether that's desirable at all. But we see at least the CNIL consultation on a mandat, as they say, to hand over these rights. But without that, we are in the realm of what also others call the My Data operators. You certainly know My Data Global and the notion of a My Data operator, which is the technical tools that basically make it easier and technically more intuitive for individuals to exercise rights under GDPR, correction, withdrawal of consent. So how does dynamic consent really work if it's very cumbersome for you to exercise it, or even if you wish to port your data from one service and allow permission the user to another one. Not even to speak about building basically the base layer infrastructure for any federated learning that could happen in private data clouds. And here again, it's to paint or to suggest an alternative evolutionary path for the personal data economy. It's not so much about banning existing data practices. That would be probably very disruptive and maybe desirable to some, but maybe also very undesirable to others. Here it's just to open another evolutionary path. And maybe some of you read a piece by John Thornhill in the Financial Times last week, where he suggested that we as Commission should not bash the big tech so much, but rather support products like Solid of Tim Berners-Lee, which also for me belongs to this group of personal data intermediaries. And I think with the proposal, we're trying to exactly do this. And we're maybe fast forwarding a little bit by providing a regulatory framework for a service that is barely existing on the market. But the idea really is here to come early with regulation to basically say, well, if these solid type of projects or DigiMe, Cozy Cloud, Mico, Schluss, I mean, there are many now coming to the markets, are to find their good place. There should from the start be a level playing field, so to say, so a general set of rules that they all have to comply with, and that rule is strict neutrality and strict limitation to only assist the individual in exercising the rights, and not having again a question whether there's monetization of the data in the background somewhere. So this is really the idea on this type of chapter, on these what we call data sharing intermediaries, and I think we're quite innovative with this one. on a note, I know that in this in the community, there's also calls maybe for more collaborative or cooperative ways to exercise or to discuss the exercise of rights under GDPR. A lot of people arguing for more collective forms of decision-making, notably the UK ODI, the Open Data Institute, building on the relational nature of many data. And that's a big discussion, I think, that is very important. Data unions are used sometimes as a term, data cooperatives. And we're trying to capture that with the proposal as well. But we also, I mean, I must personally admit, we have seen Swift health data cooperatives for many years off, but maybe the moment will come at any moment soon, and then we will see also these cooperative forms. Whether then the individual could be bound by a majority vote or whatever is the decision-making mechanism in cooperative, that's a thing that has still to be seen. The way I read it, and we also read it inside the Commission, is that everyone is exercising basically rights under the GDPR for him or herself and can't be bound by any majority vote. So in that sense, we are quite careful also in the proposal, and recitals suggest that to say that you can only be informing your own choice by listening to others and see what impacts maybe your own choices will have on rights of others, if inferences can then maybe have adverse effects of members of the same group. And that's all what you know. My third point, and my final point and last point is altruism. Here, we try to say that the concept of altruistic making available of data is desirable as such, and that we should provide a certain type of way in which it could happen, but by no means saying this is an exclusive way of doing so. So many good initiatives are taking place at many different levels, and they should not be disturbed by bureaucracy or over-regulation. What we're trying to do is two things here. We would like to set up a consent form that basically gives a standard type of language for what is considered normally as broad consent under the recital 33 of the GDPR. There are some initiatives here and there. In my own country, Germany has done that for health. There's now in the so-called Medizin Informatik Initiative, a medicine informatics initiative. There's a template now, 4 pages to use, and that for me has then to be accompanied actually by a mechanism of dynamic consent, because you need to basically monitor what happens with the data that you broadly consented to, and there should be a really intuitive means to be informed about what's happening. And then also maybe you want to specify or revoke your consent if you feel that it's you signed up to something that was actually not in your best interest. But this is a bit of a, if you want, a little support on that front. And then secondly, we could think that there could be a professionalization to a certain extent of altruism. And when I say professionalization, I'm not meaning profitability, but rather that in the end that we want to support the NGO sphere and the academic sphere to be encouraged to set up not-for-profit organizations that would then organize data pools in a manner that could also be then get to a useful size. And again, this is rooted also in ideas under the French AI strategy that this could actually be informing even machine learning for common good causes. But many good projects are going on at city level in France. The Maison Faux Self-Data Territorial is one of these examples. And we certainly will see more of that where citizens will want to actually give things back to the community. Or Barcelona, I mean, everyone knows the Code project of Francesca Vrije. This is also one of the, which is, by the way, a project funded by the European Commission, which is maybe to design these communal spaces. And so to give this a little push without over-regulating, that's maybe the third point on data altruism. And these maybe are my top 3 picks from the data governance proposal. Maybe if you allow me one last word before then hand over also to Cornelia. We also say that there's an international dimension to this, and you saw maybe some parts of the proposal that allude to international data access. Here again, this is completely complementary to the GDPR provisions on international data flows, but trying to maybe to emulate a bit certain notions from there and to expand protection also to commercially confidential information, but namely trade secrets, and also to IP protected content, that companies who have given data into a public sector database could feel comfortable if ever there was a reuse of this data, that also here is a certain protection that travels with the data. And the same goes if they transact now as companies commercially confidential information through a data sharing service provider, that also there would be guarantees that they could be ensured that no governmental authority could access such data other than for legitimate purposes, and that would be law enforcement, but also other administrative processes that enforce the law. Maybe I'll stop here, and I'm happy also to look then later at questions.
Hi, everybody. Can you hear me?
Yes.
Hello? Okay, perfect. Thanks. So first of all, hi, thanks to FPF for inviting me and the Brussels Privacy Hub here. Delighted to be in a conversation with Malte. We have met each other a couple of times on the topic of data. So this is obviously a very brand new proposal. With as Malte already said, key areas: the reuse of sensitive public sector data, an evolution of an existing regulation, the very new rules on EU-based data sharing intermediaries, and rules on data altruism. And I think it is really commendable that the Commission has taken very innovative approaches to areas that, as Malte described very knowledgeably, have been discussed over the last couple of years in areas that really think about the use and the benefits of data, and not so much on data ownership. It's interesting, I think, to see the evolution of that conversation moving away from data ownership to other terms, and it's eventually even the spirit to think about data altruism rather than data ownership today, where we are all addressing social challenges that I think everybody understands now fully, in particular in the context and in the view of the crisis, the COVID crisis, that doing machine learning and receiving or getting insights from data on more data is better for everybody. There's interesting conversations, I think, that will continue to be advanced by the academic environment in which the Brussels Privacy Hub is organized around the data subject rights versus societal quests. We've seen this occurring numerous times, in particular, for example, with tracing apps and privacy versus health safety. So that's a really interesting conversation that I think will continue to advance. I'd say from a Microsoft perspective and our preliminary assessment of the proposal, it's of course a little bit too early to understand fully all details of the proposal. It seems to us that the proposal is very much in line if or we share, let me reframe this a little bit, we share the European Commission's overarching goal that such an enabling environment to share data advances Europe's digital goals and global competitiveness. The way how to get there, we'll have to obviously see how that really functions in practice. Going back to the terminology that The Commission has been using data sharing intermediaries. It's a new word. Data altruism is a new word, and always when we have these new scope discussions at Brussels level, they will be the most heated discussions in legislative processes in determining really what this means and for whom it means what. So on our own data sharing messaging, we have really focused on allowing others to share data in a very privacy respective way. We believe that the European strategy for data sharing has become increasingly important in this context. And we have also ourselves encouraged greater data sharing across both the private and the public sector. Our steps that we have promoted are summarized in our open data campaign. We believe that is very much in line with the Commission's ambitions here. We are working together with the Open Data Institute. It's one of the initiatives that Malte has already mentioned. Important theme in particular in the context of GDPR is, of course, the themes of openness, usability, empowerment, security, and privacy. This openness and data collaboration has to go hand in hand with privacy laws. Our own research, Microsoft Research, has invested significantly in enabling data sharing initiatives while not putting data protection at risk. Examples include differential privacy, allowing organizations to share information about the data sets by describing patterns in it, but without disclosing personal data, as well as confidential computing. So protecting the data while it is in use. And we do hope that these types of underlying technologies will help to address some of these privacy concerns. I would eventually say that, and for those who have been following, the Data Governance Act was obviously very interesting to see the changes of leaked documents that were circulating in Brussels before the final proposal was adopted. And one change that I have noticed, there might be others, and Malte can share certainly some light into the detailed discussions, was the necessity of a main establishment for data sharing intermediaries in the first leaked version. That is not to be found. We understand there were concerns this actually infringes WTO rules, so this is eventually also something to be discussed. We do hope that, and this is our own view as Microsoft, a company based in the United States, that in order to enable this data sharing and really AI, that the market access will allow European companies to choose what they believe is the best state-of-the-art technology in order to compete themselves on a global level. Areas that for me would be extremely interesting to hear from Malte is, of course, how this will, this proposal specifically, he already focused on the interaction with GDPR. We will also have to see how this will interact with sectoral initiatives. I think health health data is in particular interesting here, but also with the forthcoming AI regulation and even some of the DSA and DMA related proposals that we're waiting to see still this month. On data altruism specifically and the research angles as well, I think the ability, we'll probably have to see how the DGA interacts with derogations provided for in GDPR in research. So that I think is also one of the issues that we'll probably have to see where member states have made use of the derogation possibility in this context, and how that now interacts with this new proposal. So that's maybe also my final remark for now, that increasingly we have for similar or the same services, diverse definitions that across multiple frameworks that interact. So we'll have to see a little bit how the consequences of this will be problematic for businesses to have legal certainty. We've seen this over the last couple of years that question marks occur. Of course, it's a challenge as the pace of innovation and technology advancements is so fast in this space, but it's just one of the things that we are constantly confronted with when trying to understand how to translate word definitions in a specific context and new services. I would leave it here and hopefully get some insights from Malte on the question marks that I've been raising.
Okay, very much. I mean, for these first remarks, I also see Hannes, Gabriela, you want to come in first and ask me a few questions. I see some coming up in the chat, and I'm happy to address those if you want.
Yes, please, absolutely. If you can start with one of the questions in the chat, but then maybe also address Cornelia's points that she raised, or perhaps it's logical to start with addressing Cornelia's point, and then we'll go to our attendees for the two questions there. So,
okay,
yeah,
very good. I hope I'm not frozen. I'm seeing myself frozen here on the screen. Really, the bandwidth is not always what it should be. I hope at least the sound comes across okay. No, thanks a lot for these observations, and it's quite clear. I mean, we're bringing novel ideas onto the legal market or the business market, if you want. I mean, they're not entirely our own creation. I mean, we take a number of experimental business initiatives as a baseline, and it's especially the My Data operators, if I can use that umbrella term for everything that is in the space of personal data intermediaries. There's been quite some dynamic investment over the past 5 to 10 years. And I think there's really also a ramp up here. I mean, we see the Flemish government now wants to collaborate with Solid. I see different announcements in Scotland, and it's slowly coming. The same goes for also certain services in the Netherlands, and also even here in Luxembourg. A startup from Metz in France is now teaming up with the local EID provider for personal data wallet, if I understand the service correctly. So we want to frame this emerging market and give it a certain name, and we certainly should look at the definition, and we think we got it right, but we're certainly happy to also discuss this further. How is this not going to go to interact with sector-specific rules? This was very important actually to a number of colleagues, and indeed health union and the possible establishment of a common European health data space will come in very strongly on this. We can only set a certain base layer of certain principles that have them to be really filled by much more specific rules, but trying also to respect a certain consistency in the approach so that the data economy overall progresses in a certain synchronized, not to say harmonized, but a certain synchronized fashion that not I would say it's a bit the accident of sector-specific discussions that then would give these type of outcomes or that outcomes, but that we bring a certain coherence to these discussions. Now, we don't know what the DSA and the DMA will do, the Digital Services Act and the Digital Market Act, because they are under definition almost as we speak. And the last weeks, I mean, insiders know that are always the most interesting weeks of when a proposal evolves. That's why also I shouldn't comment on the quality of documents that leak at any point, because they could be very badly distorted versions of a working document that we had on our desk at some point. So I'm not at all commenting on that one. But here on the big text, I think we are not trying to do anything that any legislation on major platforms could do. We're rather trying to, as John Thornhill was saying it in the Financial Times, to say there's maybe also another evolutionary path with new types of intermediaries that could come in here. And on the AI regulation, well, from what I know, and it's very little, and it's a long time I haven't spoken to the colleagues, so don't take any of this as a very well-informed opinion. But what I understood so far is that this would be more looking at actually risks posed by AI-driven decision-making process and services, whereas here we are in the situation where we say, well, first we want to make sure that the systems that we can buy maybe in the future or use in the future are actually also as good as they could get. And what we often hear is that a lot of the services that come to the market in Europe have never been trained on European data, and so they are almost malfunctioning by design because they haven't been really working on the target population. And that's really the challenge, I think, where we also have maybe a broader discussion in society whether any of these, well, whether all of the systems are really desirable, but some may actually be. And if we find desirable systems, especially in terms of alleviating doctors' diagnostic work, we believe there is possibilities to see benefits in AI-driven systems. But then let's also have them trained with the best data that we can find, and find also mechanisms how to design it so that everyone feels comfortable with this arrangement. That's maybe how I see the relationship with the planned AI regulation. Why did we not open? That's the question by Felix Zopf in the chat. Why did we not modify implicitly or even explicitly the GDPR? That was really something we didn't really see necessary for data altruism. I mean, the view that we would take is that the GDPR already makes altruism possible. It has all the legal tools that you need to consent to an altruistic purpose. What we felt is maybe there's a little maybe of a trust issue still. Why would I trust that the document I'm signing is actually good? And that may be where we say we invest in a public exercise to design a consent form that then can command a certain trust, and then the professionalization of the sector by saying, well, could NGOs, I wouldn't say like the Red Cross, but I mean academic institutions and also philanthropic institutions, could they actually play a useful role to organize a bit altruism, which should still happen on a local basis. I mean, we did it here in our business development district. There were also some app that we could download just to have our mobility patterns recorded for a month's time, so that on a very local basis we would basically give our data away for that purpose through a dedicated app that we would have on our phones. That should be perfectly possible. That's not the scale you maybe need. You need a local population, but if you need larger scale data sets, then maybe you need to have someone who administers this and also looks over the good use. And ultimately, I mean, maybe you know the Yale, the YODA project by Yale University. I don't know what the OND stand actually for, where also an academic institution that offers secure processing environments and puts all the safeguards in place that you can think of in terms of processing such data. Maybe a last word. There's a question. There are more questions coming in. by Esther Horn, the role of the research infrastructures. Well, by all means, I mean, this is, I think, where where data infrastructures are already quite tested in terms of openly accessible infrastructures. And our Open Science Cloud that the Commission is funding certainly needs to play a role in the dissemination of research data. Would they be covered as data sharing intermediaries? I mean, it really depends on the exact type of role they have, and whether there are concerns about a data use of the data in the background that you would normally not expect. I don't think this is really a big concern in the area of research infrastructures, but they should really have a role in here. For the public sector data, we didn't really want to go there, not to interfere with that type of policy. So the chapter 2 is focused really on public sector bodies other than educational and research establishments. So this is really more on the facilitating role for those. I'm seeing now, well, we have already cleared how concerned is Microsoft. Okay. Well, just to say, there should be no concern by Microsoft, because there's no seeming desire to keep all EU data in the EU. I mean, for the personal data, that's already not possible, because the GDPR tells you and us that the protection can actually travel globally to almost any country under the specific safeguards that most of you know better than I actually do, because they're specialized colleagues on this. So we're not at all going for that, but what we want to do is that a certain element of protection that people feel they have in Europe can travel with the data, even when the data go to a third country. That's why also there is no, I think, de jure or de facto data localization. What it does, I mean, that's you spotted in Article 5, is that there could still be a decision in the future, by a future legislation, that you really say, well, here is now a type of data set where, I mean, the EU legislator, Parliament, Council, on the basis of a proposal by the Commission, would say, well, these data should really stay in Europe. I mean, the debate could still happen, but we push that basically to the future. Okay, I'm seeing questions almost popping in as fast as I can answer them. I don't know. Maybe I should take a pause here and give
yes,
maybe Cornelia also the chance to react.
Unfortunately, we are already almost at the time to start the first panel, but I want to give Cornelia the chance to say, a concluding word, if possible. And thank you so much, Malte, for your openness and for being here today. Cornelia as well. So Cornelia, a closing remark.
Yes, I'm obviously not surprised that most questions go to Malte, given that there is a new proposal, and I'm glad that he answered exactly what I would have said. My understanding is that there is no such desire. The Commission has, in particular, Commissioner Reinders, who is responsible for international personal data transfers, has always supported international data transfer, so have multiple other commissioners in the Commission. And from a Microsoft perspective, we believe it's the customers that have the best view and when and how they desire data locality that we provide for our commercial customers and public sector customers. So that is the position we have provided. For those interested, we have also just recently issued by our Chief Privacy Officer a blog on defending privacy commitments that we have added as safeguards for transatlantic data transfers, that for those who want to have a look, you'll probably find it very easily on Microsoft on the issue blog. And with that, I'll hand over Gabriella.
Thank you so much.
Thanks.
Thank you so much, both. This was incredible, and certainly so much to follow under this initiative. I will now pass the floor to Gian Claudio Malgieri for the first panel of the symposium.
Thank you so much, Gabriella. Thank you to Malte and Cornelia. I think that it was a great introduction, extremely timely, extremely necessary. So I'm Giancarlo Malgeri. I'm Associate Professor of Law and Technology at EDEC in Lille, and also I'm affiliated researcher of LSTS in Vrije Universiteit Brussel, and member of the Brussels Privacy Hub that I represent here. So the topic of today, of this first panel, but in general of the Brussels Privacy Symposium, is extremely timely. I'm very grateful to the Future of Privacy Forum and Brussels Privacy Hub, so Jules, Omer and Chris Cooner, to have asked me to co-organize this event together with a great colleague like Gabriela Fortuna Zamfir, because I mean, I also had the chance and the opportunity to edit a special issue of Computer Law Security Review just last July on this topic, data protection and research, and some of the authors are here in the in the panelists. So I'm going to introduce this great first panel. So this great first round of panelists that we have here. So first of all, I have the pleasure to have here Dr. Chiara Staunton. She's a senior lecturer in law at Middlesex University and the program leader of the LLB. She's also senior researcher at the Institute for Biomedicine at URAC Research in Italy. And she conducts research on governance of new and emerging technologies, medical law, bioethics, and privacy in research. Then we have Claire Guérel. She's deputy head of supervision and enforcement at the EDPS, European Data Protection Supervisor. She worked for, I mean, even before being a member of European Union institutions, she was a researcher because she worked at CREEDS, Research Center in Information Society and Law. Then we have Dr. Dara Hallinan. He's a legal academic working at FITS Karlsruhe. His specific focus is in the interaction between law and new technologies, but particularly we know him for his research on, I mean, for many things, but also for his research on genetic privacy in biobanks and genomic research. Indeed, his PhD thesis was exactly on this at VUB. And then we have Dr. Henrik Junkelwitz. He's a computer scientist expert at the Joint Research Center of the European Commission and at Vrije in Italy. But actually he has a background of physics. So, but now he's working as a project officer for machine learning and cybersecurity research project. So we have researchers who are subjects and objects of this topic of today. We have EU institution representatives who are also researchers at the same time, or were researchers, and different backgrounds here. We have data protection law, we have machine learning, we have medical law. So I'm very, very excited to have this mix and a lot of topics on the table. So let's start. I mean, we have a lot of questions about the impact of the GDPR on research, the impact of COVID-19 on research, the impact of COVID-19 of data protection and privacy. So just to mention one, the issue of vaccine, which is now the buzzword for everything, and the role of AI in this, and more privacy related topics that we will have the occasion to address, like the issue of definitions, definition of research, definition of sensitive data, the topic of lawfulness, derogations, the notion of consent. So I will start with Chiara. So you conducted research about medical regulation, medical research regulation, and how the GDPR affected research ethics, also looking at the global health divide. So I wanted to ask you about these topics and to hear your view. Thank you.
Hello, everyone. It's lovely to be with you all. So I think the impact that the GDPR has had on research, I think very much depends on who you ask. Some say that it's resulted far too much in bureaucracy, it's hindering research, and it's stifling innovation. And there's even the argument by some that it shouldn't be applying to research at all. And then on the other hand, we have those who say that it offers too many derogations and exceptions for research. What I would say is I absolutely don't agree with the contention that it should not apply to research. As we've mentioned already, we're in the era where there's a push towards open science and making data available. And the benefits of this open science movement are well discussed, you know, and absolutely accurate. But when it comes to research, we are dealing with sensitive information that is often health information. And there are risks in the sharing and the processing of this information. And the use of this data raises a lot of concerns, including individual and group privacy, as well as risks beyond that, such as stigmatization and discrimination against individuals, groups, and minority populations. And as well, there are other risks that can arise depending on the context in which the data is used, the vulnerabilities of the individual or the population, etc. Now, some of these risks are real, some are perceived, but I think this perception is so important because of the public trust that is in research, that it's so important in research. And because of this need to guard and protect the public trust, we have to guard against all these real and perceived risks. Now, traditionally, up to very recently, in research ethics, privacy was very much protected through informed consent and or anonymization. But the limits of informed consent as a means for the data subject to protect themselves have been well discussed. Now, it does, of course, informed consent respects the autonomy of the individual, but questions have rightly been asked about the extent to which consent can be truly informed in many research projects. I myself give the example of, I have donated cells to biobanks. I have been working in this area for about 10 years. What degree of my consent was truly informed? Very debatable. Now, when we turn to anonymization, we now know that anonymization is not always desirable because the data can lose its value, but also it prevents the data subject from withdrawing from the research itself. So the benefits of the GDPR is that it requires a focus on privacy and data protection at the conception, at the very beginning of protocol development, right throughout the life cycle of the project. And how you protect the participant, guard against or protect the privacy of the participant goes against consent and anonymization. And so issues of compliance and data protection are to be addressed at the outset. So this requires researchers to be proactive rather than reactive, as we often see. Now, if in strengthening rights and protections for data subjects and research participants, and the introduction of more accountability measures results in an increased administrative burden for research, I really don't think that this in of itself should be the critique. The focus can't be on the lowering of the rights and the protection afforded to data subjects, but the focus should be on how best to strike this balance between individual rights of the data subject and the research participant, and more collective rights and more collective rights that research seeks to achieve. So on this, now, while recognizing that data protection is a fundamental right, the GDPR does recognize itself that it is to be balanced against other important rights and interests. And for this, there are a number of derogations and exceptions provided for research. So to both sides of the debate, depending which way you would sit on, I would say that the purpose of the GDPR is not to hinder research or restrict the sharing of data for research, nor is it to provide a free-for-all for researchers, but it's to ensure that personal data is processed for research in a manner that safeguards research participants' privacy. And I think for me, it's these safeguards are key and that we really need to have a discussion on. Now, some of these are stated within the GDPR itself, but I think we also need to look beyond that and to consider what are all these, what could be other safeguards. And I think for myself, a lot of my work that I've done is on the impact of data protection regulations in the African context. I actually think that we can learn quite a bit from our African colleagues there, where there's a huge focus on community engagement. And community engagement is increasingly seen as important for the ethical conduct of research. And so this engagement can be a safeguard in of itself, but it can also feed into the development of safeguards but it can also feed into the development of safeguards as part of data protection by design. Now, on this last point, again, on the global context, what I would like to say is that, and it's kind of raised concerns, is that the GDPR is seen as a gold standard, and for many reasons, many jurisdictions across Africa have introduced legislation that's very similar to the GDPR. And of course, the strengthening of data protection regulations is to be welcomed. But what has to be discussed and what focus, which we haven't had to date, is the impact on that, the strengthening of the data protection regulations and the impact that this is going to have on cost, resources, finances, and the cost of meeting these new standards in global health research. Now, I did quite a bit of empirical work on this matter during the summer with stakeholders in South Africa, and they raised the concerns that this could mean that it's only going to be well-resourced institutions that could afford to meet these new standards. So when I'm going to finish on this point, I think the question that we now need to ask is, how do we actually balance meeting these new standards with the need to ensure that the GDPR is not actually going to perpetuate global health research inequity?
Thank you very much. I mean, very, very effective and straight to the point. So actually, you raised like a challenge to the GDPR in particular. So I'm very happy now to pinpoint to Claire Geihel from ADPS. So we have a lot of things on the table. Also, Chiara helped us to develop these points, the point of consent, the point of safeguards, and the balances of interest. So, we have today also, we will have the final keynote, who is the EDPS in person, but Claire was one of the people who worked also at a document that was released just 11 months ago, the preliminary opinion on data protection and scientific research from the EDPS. So what's your, that was the first document of the EU interpreting a bit the research rules in the GDPR. So what's your view on these, at which level we are, and also, looking at the challenges that Chiara was launching?
Thank you, Gian Claudio. Good afternoon, everyone. I hope everybody can hear me well. And thank you for mentioning my past career at the university, because indeed it is relevant in this context. I've been a researcher myself, and I very much, I think, understand what are the challenges the scientific research community is facing. A few words about the background of the EDPS preliminary opinion on scientific research. I think this has been very well summarized already by Chiara, because she referred to a situation that we also observed at the EDPS. The situation was that very quickly after the entry into force of the GDPR, we were facing between two rather radical or opposite interpretations about the impact of the GDPR on scientific research. On one side, some were claiming that the GDPR was offering too much flexibility, that taken altogether the broad definition of scientific research with the derogations to some of the core principles of data protection, like the principle of limited retention or purpose limitation principle, with a special provision under Article 89, would provide the basis for an excessively liberal interpretation of the GDPR that could open the door to many abuses and risks. And on the other side, we were listening to other stakeholders telling us that the GDPR established an overly restricted regime and was preventing advances in innovation and research. And so between these two somehow extreme interpretations of the impact of the GDPR, we thought that probably the truth lies in between, and that there was a need to somehow bring a direction into how the GDPR should be understood in relation to scientific research. So that was one of the intentions of this preliminary opinion, also taking into account new current trends in scientific research and increase the increased role of private parties, the increased roles of availability of data, open data, reusability, etc. So the will was not to sort out in details how the GDPR applies to each and every instance, but to discuss some important trends and start indeed an important discussion in this respect. And this opinion also addressed in part or pointed out to a trend regarding consent and the role of consent in the context of research. And I think, Gian Claudio, you wanted me to come back a little bit on this, and I will try to explain how we understand at the EDPS what is going on. Obviously, informed consent is a cornerstone principle of research ethics. And I think that in the past, as a logical consequence, the data subject's consent to the processing of personal data was conceived as the natural lawful ground for scientific research under data protection law. And that was the case under the Directive 95/46, I believe, and in most member states, and that was a natural lawful ground. And in that sense, informed consent and data subject's consent were inseparable or indivisible. But we believe, or we observe, that the DPS, that this well-established approach, was somehow evolving and less relevant, and taking into account different trends. On one side, research in the online environment with limited direct contact with participants, or the constitution of large-scale genomic databases used by multiple researchers over long periods of time, were questioning more and more the role of consent and informed consent. Ethicists themselves were questioning whether the function and efficiency of informed consent in today's scientific research practices. And here I want to refer briefly, but there are increasing practice of broad consent, but not only broad consent, very broad consent, where people are asked to consent to the further use of their data for research purposes. And this sometimes without any further restrictions on these uses. We have also been facing the emergence of open access consent, meaning people are invited to make their data, sometimes genetic data, very sensitive data, available online with almost any restriction for use as well. There have been also evolution in consent by rewarding consent in participating in research itself. All these practices raises new ethical concerns, also in the ethical, I would say, arena. And then what happened in data protection law? On the other side, there was another trend, which was to straighten consent. And the negotiation of the GDPR and the new, in a way, the straightening of the conditions for consent under the GDPR with the related right to withdraw consent was pushed, and somehow come also to question the suitability of data subjects' consent as a lawful ground for the processing of data in the context of research. The requirement for a freely given consent has been questioned in some instances where consent is provided in exchange of reward, or when obtained in context where the data subject is in a particularly vulnerable situation. The requirement for specific consent, which has been the object of interpretation by the EDPB, but not only by the Court of Justice now. We have, I think, about Planet 49, more recently, the case law Orange, Romania, where the Court of Justice has elaborated on the conditions for specific consent, also questioned quite frontally how this condition can be applied in the context of research, where broad consent and increasingly broader consent is becoming the practice. So from these observations, we consider that this was becoming less and less relevant to consider informed consent and data subjects' consent as a single and indivisible requirement. And this is why supervisory authorities, the EDPB and the EDPS as well, is also accompanying this direction, the role of consent in the 21st century research, which is very much driven by data, reusability, availability in open data frameworks, should lead us all to question what type of consent do we want? What is the place of consent? Is it a data protection consent as a lawful ground for the processing, or would it be more meaningful to make it a safeguard? And this is somehow one of the paths that is now opened by supervisory authorities. Indeed, in many instances, consent will not be a valid lawful ground, but could be used as a safeguard. And this is where we believe that the dialogue with ethical community, patients organizations, research organizations could very much help to clarify or to define the conditions where this consent is applicable under which conditions to make scientific research add-ons.
Thank you so much, Claire. I think that point of consent as a safeguard could appear a bit heretical at the first moment, but then was a nice compromise. I mean, something very creative in terms of, let's say, also research on this topic. So Dara Hallinan, you had a lot of also researches and studies also on the role of consent. So how do you see this topic, and in particular in research, and so also in a dialogue with what Claire just said?
So thank you for the question, Jean-Claude. A lot of what Claire said, I would very much agree with, perhaps most in the way she expressed it. So expressed the difficulties in defining exactly the role consent should play, etc. so eloquently and so diplomatically. It's not an easy question. I would drill down a little bit into your question and focus on how we are understanding consent now in data protection law and its relation to research, and the series of messes I think we are making on both a policy and academic level. I want to point out 3 problems in particular and point out some directions we might take opposed to those we're taking now that might ameliorate the problem. So the first issue is I think we're forgetting the basic function and importance of consent. And this manifests most obviously in the description of consent as a safeguard. So consent is the word we use to express the mechanism by which the right to informational self-determination is realized. Whereas a safeguard is an effort to channel behavior in order to minimize the risk to an otherwise exulting or existing object or value. Consent isn't a safeguard. It's an integral part of the right to informational self-determination. So when there's no right to informational self-determination, consent is irrelevant, as it doesn't safeguard anything else. And when there is an informational self-determination right in relation to some aspect of research processing, then to consider consent as a safeguard is a misleading use of the concept of a safeguard, and ends up describing or simply bringing confusion to the unique function of consent in data protection and in terms of the underlying rights, and to minimizing its quite unique significance in relation to these rights. So the second problem is that I think we're treating consent in data protection as something of a freestanding entity, completely detached from other areas of law and ethics relevant to research in which consent also plays a role, as well as detached from the practical circumstances in which research is conducted. So in doing so, this naturally opens up the possibility for the way that consent is considered in data protection law to simply contradict other areas of law and ethics relevant to exactly the same processing activities, which seek to answer exactly the same questions as to the use and conditions of consent. And it also opens up the possibility for the way that consent is used in data protection law to sit in direct contradiction with the reality of a processing situation. And the most obvious example of this, I think, is the position we seem to have taken in relation to consent in data protection in clinical trials. Under the current position, the concepts of freely given consent in data protection law and in clinical trials law have been set in rather direct contrast to one another, unnecessarily, I think, even though they deal with precisely the same relationships. And under the same propositions, consent is supposedly not the basis for the processing of personal data, despite the fact that the individual has to have given their consent for the trial to occur, and therefore the processing of personal data to go ahead. That is, at the very least, incredibly confusing. So really what we should be looking to do is to reconcile, wherever possible and in as far as possible, the various different approaches to consent relevant in relation to a data processing situation in research, and for these to align with the reality of a processing operation such that the complex of laws is understandable and cogent. And the third problem, and building on the second problem, is that we're looking for answers as to whether and how, or when and how consent as a processing ground should apply in research by looking to data protection law alone. And this will be fine if data protection law provided like extensive grounded normative thought when it came to consent in research. And when consent should be used and under which conditions it would be considered legitimate. But this really isn't the case. The GDPR constitutes omnibus legislation, which provides very little normative insight into the relationship between consent and research. But the GDPR still tries to seek ethical outcomes in data processing. And in this regard, it's a framework which still needs to be filled with normative information as per the relevant sector, as per the relevant or the specificities of any given processing operation. So we take the current results or the current approach, it simply results in conclusions that rob the GDPR of any sort of ethical heart, and which stand in contradiction to a large body of thought on the use and the conditions of consent in research ethics. One example of this is the repeated idea that the GDPR and its various processing grounds should leave the decision as to which ground to pick completely up to the processor or up to the researcher. What we should be trying to do is filling the normative gaps in the GDPR with thinking on when and how consent should be relevant and necessary and legitimate in research, with the vast stores of this form of thinking, these ethical thoughts that are already present in research ethics and the countless instruments and processes of research ethics.
Yeah. Thank you, Dara. Thank you very much. I mean, you see, consent is a bit a Pandora box, and I also was, participated in this fight with other views in the past. I mean, there are enthusiasts of consent, and there are like more pessimists, and maybe I tend to be pessimist, but I like other views, and there are some questions about that. I remember to all attendees that they can use the Q&A. We have already like 5 questions, so the member of the panel can see a bit the questions. We will have some minutes at the end to reply. Now I will go to something which is a bit also a Pandora box, which is AI accountability and explainability. So I wanted to ask Henrik, I mean, what do you think are the challenge in a specific field of research, which is AI research? So what are the challenges of current AI research and applications in the context of the GDPR, personal data processing, looking also at accountability of algorithm and explainability? I mean, COVID-19 is of course impacting these. So what's your view on these? I mean, now we zoom a bit on a specific field of research and with you. So
yes. Thank you, Giancarlo, and thanks for the invitation. Yes, so I mean, there are many important challenges and issues and opportunities to be looked at when discussing these topics and current AI developments and GDPR together. I'm not a legal expert, as you already mentioned, so we'll be looking at specific technical limitations and challenges to some of these questions. And I will also move a little bit into the question of AI applications in production and how that relates to research. So first, let me emphasize, when we're talking about AI in this context, and with relevance to the GDPR, we're mostly talking about machine learning, which has also been powering the most recent advancements in AI. And this is a very data-intensive field, so obviously a large set of issues arises from that. That is because of the sustained need of data availability, and therefore it touches upon many of the rights of data subjects. But secondly, machine learning systems have an ever-increasing algorithmic complexity to them. So given the question, how you posed them to me, I'd also like to focus specifically on these points, that what does that mean for algorithmic accountability and explainability issues connected to the GDPR. So, and around these issues, there is a lot of discussion about what actually constitutes a meaningful information about the logic involved of the system, as is being asked in Article 15, or the whole discussion about the possible right to explanation. I'm not going to enter this legal discussion, but I'm going to point out a number of fundamental technical questions connected to this and to questions like how do we even realize algorithmic accountability, tackling biases, fairness, transparency, and these topics from a technical perspective. So it's not at all clear or settled in the technical environment how much and under what circumstances algorithmic capabilities that could provide such elements could actually eventually match what is legally required. So examples that you already mentioned is, and that the panel discussed, for example, consent. Consent, as far as I understand, might actually be borderline meaningless when the system that is being used to process the data is not transparent or cannot be guaranteed to be understood because it's a black box and it's not sufficiently explainable to the data subject. Or rights to contest a decision involve humans in the loop. So what if we cannot guarantee that the people involved understand the AI system or the explanations of it? And there's in general no reason that techniques from the field of explainable AI will be in general sufficient to produce explanations as being asked for by the legal context or from the context of the situation. So an explanation might be very different for a researcher, developer, or a data subject. So given this large range of technical problems, even if we might be able to handle those in the research context, because then it might be easier and clearer if I get the consent and if my system works. And let me emphasize that especially for machine learning development, the lines between research and moving into application and even production-ready systems are quite blurry. So often models come from the research context and then they're reused or adapted using transfer learning approaches. Tech companies conduct research and provide solutions. So here's where I see a central issue for this. We simply cannot assume that when we rush those systems from research into automated processing environments, that they will behave correctly according to the GDPR. And this has clear implications for the COVID-19 situation, which, if anything, has exacerbated and highlighted these type of issues, because we have seen exactly such an uptake of ML systems coming from research. There's a lot of research, but moving into applications quickly from contact tracing to triage. And we have not been able to settle issues on accountability or explainability in this. So I think it's highlighting and exacerbating this enormously, at least for us as to discuss it. Yeah.
Yeah, thank you very much, Harik. Yeah, I mean, and so actually we started to explore with you how COVID-19 impacted research. And looking now again at the broader picture of data protection and research, I will go with the second round of questions more related to COVID-19 and research to all panelists. I will just ask please to be short in your answers because I want to have some time. I'm seeing there are like 12 questions now. No, yeah, something like 12 question and answer now. So I'm trying to type in there. So again with Kara, how do you think COVID-19, I mean, has impacted like the regulation of research in the EU? I mean, do you think that the balancing between private and public interests should be rebalanced according to the pandemic? We will address this also with other panelists. But I mean, what's your view of this, I mean, the pandemic impact on that? You are muted.
Thank you. There's always one. I definitely think we need to take stock and consider it, how it has worked. You know, it's a pandemic where there's an absolute clear right of the way. There's a need for timely access to reliable data to track the spread of the virus and prepare an effective response, test, treat, etc., and developing of diagnostic vaccines and therapies. So the importance of access and sharing of data could not be more obvious, particularly across borders. Now, but it's clear that research is in the public interest. But one cannot forget that the safeguarding of the rights of data subject rights is also equally in the public interest. And in considering this wider public interest as it relates to research, we cannot and we should not take a purely consequentialist approach and focus on the end goal, which I assume is the development of diagnostic therapies and vaccines for COVID-19. We really need to consider the process in which we are going to achieve this. So we need to ask ourselves if the limitations are on rights and freedoms are a necessary and proportionate response. And if there are limitations, how are we going to go and continue to protect the research subject? And I think this is important for a number of reasons. One is we have evidence already that the emergency has been used as a justification for introducing restrictions on rights and freedoms in other contexts. And we absolutely need to be careful that this is not done in the research context, because we know that maintaining trust is essential to research. I said it again, and I'll continue to say it, and we cannot let this trust be damaged. And this is so important when we want the public to trust the science. We want them to get tested. We want them to take the vaccine when it's available. So in our consideration of the public interest, we need to consider the wider research ecosystem and not just the end goal. And I think this is also, it's arguably our first digital pandemic, and there has been a development of a number of digital tools to respond to COVID-19. But consideration of how we maintain data protection safeguards and safeguards that will help promote trust must be part of any public health response. And any limitation on this rights that we have in responding to COVID-19 for research absolutely have to be necessary, proportionate, time limited, and transparent. So I think I'd leave it there just in the interest of answering as many questions as possible. But I think it's absolutely essential that it's not just the research we consider in the public interest, but the wider protection and importance of protecting research participants for both the individual themselves, but also for research generally in considering this public interest.
Yeah, I did the same. I was also muted. So yeah, thank you very much, Kara. I think you really, touched upon the most important point, which is like public interest and also the derogations of privacy for public interest and the derogations of data protection rules. So we have again Claire, who also worked at the EDPB guidelines 2020 about COVID-19 research and data protection. So what's your view, Claire, in particular on this topic of derogations for public interest and exceptions to GDPR rules? I mean, you also interpreted a lot of these points in that interesting and very rapidly written guidelines.
Thank you, Gian Claudio. Yes, indeed, the EDPB issued a set of guidelines in April 2020, pretty rapidly after the beginning, let's say, of the sanitary crisis. And this was because the pandemic shed the light on a number of urgent questions that were raised to national essays, given the fact that many research projects, clinical trials were starting in a total rush, in a way, and there was an urgent need to provide some sense of direction and guidance on the interpretation of some of the derogations available to scientific research in the GDPR. So the EDPB worked on these guidelines, trying to address some of the most striking issues, in particular in relation to lawful grounds, so again, consent or not consent, transparency, and international transfers. So with regard to the lawful grounds, the guidelines provided some examples in which consent can validly be used, because I emphasized the fact earlier that consent may not be the most suitable ground for many research projects, but it doesn't mean that consent has disappeared. It can still be a valid lawful grounds, obviously, when all the conditions for valid consent can be met in certain circumstances, and this can be the case. And the EDPB also pointed out to some examples where this could be possible. We also pointed out to the possibility to rely on national legislations, and I'm not sure to which extent member states had adopted specific lawful grounds in the context of the pandemic and for scientific research, but I've heard that this have been the case. So I think that in this area, there may have been more availability of alternatives to consent, because it's true that the alternative to consent is not always available. So to respond a little bit to Dara, who said that we have introduced huge confusion by somehow sending a more cautious message about the use of consent in research. I think this is because the scientific research community may be a little bit frustrated because if they don't have consent, they don't know on what to rely on. And indeed, there are other legal bases available under the GDPR, but those legal bases are not always, or not directly operational because they require further adoption of national laws. It's the case for Article 9.2J or Article 9.2I. And indeed, I think the dot that is missing is sometimes the implementation of this legal basis into national framework or EU law framework to provide the operational, I would say, usefulness of this lawful ground. And the guidelines also shed the light on the use of derogations to transparency, as a number of them could be relevant in the context of the pandemic. Article 14.5b, notably providing for the possibility to derogate to the obligation of information when it proves impossible or would involve disproportionate effort, has been flagged as a possible derogation, and the EDPB is aware that in a number of contexts, this derogation could be activated in particular. And finally, I believe that the area where the guidelines have provided important guidance and I would say interesting guidance concern international transfers. The guidelines point out to the derogations as a possible legal basis for transfers in cases where no adequacy decision was in place or where there were no appropriate safeguards. And it's clearly stated that the COVID-19 pandemic caused an exceptional crisis of an unprecedented nature and scale, and that the fight against the COVID-19 is an important reason of public interest recognized by EU and member state law, which may require urgent action in the field of scientific research involving international transfers towards international organizations or other third countries in the context of public-private partnerships in particular. So this derogation of important reason of public interest was also not limited to transfers between public authorities, but also for private entities that could rely on it to further liberalize the flows of data in their partnerships. So we believe that this was an interesting, I think, contribution at that moment. The EDPB also called for stable arrangements and stable partnerships to look for appropriate safeguards. But the EDPB obviously understood that those safeguards or those set of arrangements could not necessarily be in place at the moment where the need to launch immediate and urgent scientific research projects was happening. So I think that the EDPB somehow even has provided, I would say, we hope, useful and realistic guidance. Obviously, the EDPB has not addressed all the questions, and some questions have been left aside because of their horizontal nature and complex nature. And this is the case for the presumption of compatibility and the reuse of data under the so-called presumption of compatibility, on which the EDPB is currently working. And I want to say that scientific research is in the annual working plan of the EDPB. So this is an ongoing work. More is coming, and the EDPB is likely to provide more guidance soon to interested stakeholders.
Yeah, thank you very much, Claire. I mean, one of the points you raised, I think, is extremely timely for COVID-19 research and vaccine between European Union and other third countries. For example, you know that pharmaceutical companies are often outside the EU. So, I mean, all this story. Dara, I mean, so what about data transfer for scientific data? I mean, 2 bombs this year. The first was COVID-19 and the second one was Schrems 2. So, I mean, how do you see this is going to change or is going to affect the whole story of transfer of data?
So how Schrems 2 is going to affect the story of the transfer of data depends what happens now. And nobody is exactly sure what's going to happen now, whether some new Privacy Shield 2 will come out, which represents some incredibly small change to Privacy Shield number 1 and just sets the whole ball rolling again, or perhaps the US government very slightly changes its policies on national security policies, which sets the whole legal discussion in motion again and makes and allows policymakers on the European side to say, everything is fine now before another case comes up. But look, basically we have a problem in relation to international data flows that concerns at the moment predominantly national security. We don't agree on national security and how personal data should relate to national security. The majority of the serious discussion on this, on how to facilitate data flows in light of this problem, is either on how we can align thinking regarding national security or how we can avoid the problems by some kind of weird workarounds, technological, legal, whatever. I'm not sure of the chances of absolute success in terms of allowing all possible data flows that are useful and legitimate under these approaches. But I think there's another question that really should be asked, and that's, why is it that differences in approaches to national security have to disrupt all other forms of personal database collaboration between states? So particularly in relation to research, do differences in approaches to national security need to disrupt all forms of personal database collaboration between states in relation to scientific research? I think that's a really important question, and it's a question that nobody seems to be asking. There are a number of further questions which require some thought to answer this top-level question. So in particular, to what degree are international scientific data flows necessary for national security in one state or another? And to what degree is it possible to detach legal frameworks relevant for national security from frameworks relevant for scientific research? I don't have clear answers to those questions. They need quite some detailed work and research. But if you can answer those questions in a way that suggests that the differences in perception and function of national security legislation need not disrupt all personal data-based research collaboration between states or countries. And I think in certain situations, we will probably be able to answer this in a positive way. Then I'd quite like to suggest an alternative proposition to take us out of this current cul-de-sac. Could we consider the conclusion of sui generis international adequacy agreements specifically relevant to scientific research, in which solutions to the problems posed by national security provisions are provided, or that the applicability of problematic national security provisions is simply excluded? And I appreciate that there are a whole series of legal, political, and technical issues which would pop up around actually making this a realistic idea. And maybe those are simply too large that the idea is workable at all. But I think it has some utility. And if it does, then we should definitely investigate before drawing conclusions. Just to point out, the idea of sector-specific adequacy or transfer agreements is not even novel. Ironically, they actually exist for the law enforcement context en masse. Nor is the idea of making research processing like something of a safe haven for certain types of third-party access novel. This is the approach that's followed in the Estonian Human Genes Research Act. It's an approach been pushed up to over 10 years ago by the German Council of Ethics. And I think it's an approach which makes a huge amount of sense given the change in the balance between, or change in the public perception and importance of scientific research in light of the pandemic and in light of what the pandemic has shown us about our vulnerability as humans and as human societies.
Yeah, thank you very much, Dara. I think your questions might be directed both to a European Union Commissioner and to the Court of Justice. I mean, we need to see if it's more a legal stuff or a political legal stuff. I have, I mean, coming back a bit on AI and, you know, I mean, the use of data today was very, very like central for COVID-19 research, for COVID-19 detection, for COVID-19 tracing. I mean, artificial intelligence was really the oil of this pandemic. So, I mean, again, I have a similar question. I mean, to Henrik. I mean, what are the current capabilities and limitations of AI for research, especially in the age of COVID-19 pandemic?
Yes, obviously that's a very huge question. I'm gonna focus on a specific fact here that that is a very transformative time, and the pandemic had a very transformative impact on bringing AI into applications or closer to application. And obviously there have been huge headline successes in AI, mostly driven by machine learning in the last 10 years or so. And some of them also impact AI in health, right? Like computer vision systems for medical imaging, natural language processing has been employed in AI bot screenings. Obviously drug discovery, just yesterday, or I think, yeah, the last days, the DeepMind has announced a huge new result in protein folding using deep learning, automated diagnosis tools, computational epidemiology. Okay, so there is a lot to learn and that we can do with AI in the health context. What I'd like to focus on is that we are in this transition, and many of these systems, again, are based on increasingly complex systems. They use complex deep learning networks. They use huge data sets and increasingly complex data types. So we are seeing a shift from tabular data and correlation analysis to very complex image, sound, cough detection has been employed in triage systems, for example. So, and this draws the attention to the limitations of these systems, or at least we need to deal with the limitation and the challenges of these systems. And of course they are there. While they're extremely capable, these systems have been trained in specific tasks, so they can show superhuman performance, for example, in skin cancer screening. That's a very famous example. But they're not going to replace, for example, complete decision-making, especially not in a high-risk scenario as a clinical situation, because they have been trained on specific data in specific situations. Then there's the whole question on correlation versus causality. So most of these systems just map huge correlations. And for some reasons, we might want to explore causal relationships. There is the whole increasing complexity of models leads to less transparency and explainability, or at least possible, that we already touched upon. I'm not even going to go into the biases and fairness question that is a huge one, especially for medical applications. And there is robustness issues with these systems. So I'm also working in cybersecurity. So these systems introduce new vulnerabilities, especially computer vision systems. And so I don't want to sound negative. I just want to say, if we are putting these things into application, we are coming to the point where we need to talk about these things. And especially in the context of the GDPR, this is again my point from before, we are now bringing things into application in this pandemic that touch upon many of these questions. So for example, as you mentioned, we have done a study on a hypothetical case of using X-ray imaging as a triage system for COVID-19. So this has actually been tried out in clinical applications in a rush in some US cases, and many machine learning systems have been applied and just augmented quickly with data, because there is no data available large enough to train machine learning systems. So we have clear examples of systems that have been used, but we have not addressed these issues. Exactly. So I'd say, where do we go from here? I think trust is an important word. I already heard that word. So the move to trustworthy AI is also pushed by the Commission, and to secure AI by ticking lots of points. We need to make the systems trustworthy by introducing proper regulation on many of those, human oversight, and make sure they're robust and safe. etc. But we also need to understand that we cannot regulate everything. So we need a risk-based approach, I guess. And health domain is a very clear example for this is a high-risk domain, so we need to take care of these things. And yeah, that's why we're discussing it, I think.
Yeah. Thank you very much, Harik. Now I'm really running for having, some Q&A replied. So I tried to make a summary of all Q&A that I found. There are 17 and more in the chat. So I was just trying to summarize a couple of them, trying to put them together. So one of the issues that our audience asks is, if there are some proofs that that GDPR really limits research, really disable research or enables research. And I think this question is also for Clara, maybe. I mean, she might reply. And maybe another question for Clara might be, I just see here, if the GDPR, let's say, enables diversity in population representation in research or not. So if, we can use some of the GDPR principles also for this or not. Then I have other question for Dara, for Claire, but I give 1 minute if possible to Kara just to to try to reply to these questions.
We hear a lot of anecdotal evidence about the impact that the GDPR is having on research. We are hearing people saying that it's too much bureaucracy, that it is limiting. I do think we need some work on this point to see what is the actual impact on it. And if it is restricting research, how is it restricting research? Is it slowing down the process of review, or is it actually stopping research carried out? So I think we need more work on this. Regarding the second point, what was it again?
Diversity of population represented in research. If the GDPR, can give some hints about this, because one of the questions is that the research is, overrepresents just some social groups, some ethnic.
Yeah, absolutely. This is a huge problem that we have in global health research, and there's numerous studies on that. I think it's an excellent point, and one that we should consider, considering the requirements of transparency, who actually is being involved in research. So I'm just going to leave it at that point, but I think it is an excellent one.
Yeah, thank you so much for being rapid. So just a couple of rapid questions to Claire. I pick from these questions. I see that there is this tension that they propose between compensating the data subject for research from one hand, or the other hand, the opt-out model. So rather than opt-in, the medical data are processed by default. So these are, I think, the two very opposite, paradox. Either you pay research subjects, or you take their data by default. What's your view about that? And the second point, Claire, is the relationship between law enforcement and the GDPR, because I see two questions about this. This is a very particular point. I didn't expect to find this question. And you have also background in law enforcement data protection. So maybe what's your view, if in particular for social research, I guess, because it's a criminal data.
Okay, thank you. Well, the question of compensating research participants and rewarding research participants for the processing of the personal data is a huge question, I believe, from a data protection law viewpoint. It's connected somehow to all the current discussion about commodification of data, data monetization. So broadly, not only, I believe, in the research context, but in the broader context. So this is raising a lot of questions, and this is somehow questioning to the very heart, what is the right to data protection? Is it primarily a personality right, or is it also an economic right encompassing some property rights, even limited, but possibly allowing some property rights? And this is, we know that there are many doctrinal discussions. I think, John Claudio, you participated actively also in this discussion. So this is a major debate. And so on this, I will not reply in law. I would just say, I believe, and this is why consent as a safeguard offers, in my view, more flexibility than consent as a lawful ground, to discuss to which extent rewarding consent might be ethically acceptable, and then accepted also as a safeguard and the data protection regulation. I think this is something that also belongs to ethical discussion, more than data protection discussion, if we take the point of view that the processing of personal data can be grounded on other lawful ground, actually. So the same for opt-out models. Why not, if in the specific models and the specific legislation, all the safeguards taken all together for in the name of a specific research objective set up by law, discussed, negotiated as a consensus, as a society, we can agree that opt-out models may be a valid approach. So there is no single reply to this. And I just wanted to add one thing about whether the GDPR hinders or not scientific research. Maybe if you don't know about it, the STOA report, or produced for STOA, the European Parliament, how the GDPR changes the rules for scientific research. I think this report is very interesting because some of the conclusions of the authors, and Effie Vaena from the University of Zurich was the one coordinating this study for the European Parliament, also demonstrates that it is much more a question of perception than a reality. So this is also interesting to keep that in mind. And I think I forgot your second question, or if I answered, maybe.
Yeah, I mean, it was about law enforcement, but I really
for the law enforcement, it's just to say that we indeed, there are opportunities for processing of personal data in the law enforcement directives, as well as in the Europol regulation. This is a little bit, it's true, not very elaborated, the interaction of the instruments between themselves. And this is something on which I think the next years are where there will be more clarity. And we are working on that on our side. But this is something a little bit, let's say.
Yeah, voilà. Thank you so much. And now I see 30 seconds to Dara, because he's the real protagonist of our Q&A. So many questions just directed to him. So just summarizing 2 questions, that if you can reply in 30 seconds. The first is the role of self-determination, maybe something that we need to pay away for research, for public interest. And also it's not the object of the GDPR. That's what one person says. So maybe, can we reconsider self-determination? And the other point is code of conduct for data transfer. Is it a good element, code of conduct for transferring data abroad or not? If you can be extremely brief, I will be extremely grateful.
Okay, here we go. We always have to reconsider the boundaries of self-determination. It's an imperative. It's what we've always done. Self-determination, what it means has changed over history, and it has to change according to social context. Do I think we should get rid of self-determination because of the public interest in research? I think this is an absolutely terrible idea. I think this is completely undemocratic in relation to allowing people to choose what kind of research they are involved in. Having said this, of course, there are exceptions that will likely become more relevant over time, as in certain cases it is not possible to gain consent. It is not possible for people to exercise self-determination, and this requires that we have other means to allow other legitimate interests to come to the fore, public interest in research, the outcome of research, etc., etc. Code of conduct for transferring data across borders. Fantastic idea. The question is making them workable such that they are going to fulfill the requirements of European data protection law and its subsequent jurisprudence. I don't know how you do that, frankly, with certain countries whose law is itself falls under the standard required by the EU. There are, technical workarounds, some legal workarounds, but they're not all encompassing. I'm sorry, would love to say more, but my 30 seconds are.
It was very dense. So thank you everyone for this. It was incredibly dense, and I'm very excited with this discussion now. Thank you everyone from the panel. We have 10 minutes break. I read from the chat. So we have 10 minutes break, and we will be back for the second panel at 4 p.m. in Europe and 10 a.m. in the US. Stay logged in and have a good coffee or tea. Thank you.
thanks to our
we are having now the second panel of the day, which promises to be a fantastic discussion among thought leaders in this space. Well, the topic of the second panel of the day will focus actually on research using sensitive data, research using special categories of data. As we know, special categories of data under data protection regulations are enjoying a heightened level of protection. And this sometimes makes things difficult for research that actually needs to take into account all categories of population and sensitive attributes of different individuals and different populations in order to produce excellent results. So how do we balance that? We've lined up an absolutely a fantastic panel. I'm very happy to introduce our panelists today to discuss exactly this tension and the solutions that we might find for this tension. So let me introduce the panelists. We have Elettra Ronchi today with us, Senior Policy Analyst at the OECD, the Organization for Economic Cooperation and Development. She's currently leading the protection, the review of the implementation of the 2013 OECD guidelines on the protection of privacy and transborder flows of personal data, and also has significant experience working on health data governance at the OECD. Hello, Elettra, thank you so much for joining.
Hi, thank you.
We also have today Paul Quinn, professor at the Vrije Universiteit at Brussels. His research focuses on data protection, privacy issues, and problems related to stigmatization and discrimination. He is also part of the Health and Aging Unit at LSTS at the VUB. Welcome, Paul. Thank you for joining us.
It's my pleasure. Hello.
Our other panelist today is Dr. Heng Xu. She is a professor of information technology and analytics in the Kogut School of Business at the American University, where she also serves as the director of the Kogut Cyber Governance Center. Dr. Xu's research focuses on information privacy, data analytics, data ethics, and cybersecurity management. Welcome, and thank you so much for joining us.
Thank you.
And last but not least by any sort of measure, we also have today with us Knut Mager, who is the head of global data privacy at Novartis, a leading global pharmaceutical company, and the chair of the data protection working group of the European Federation of Pharmaceuticals, Industries and Associations, FPA. Welcome, Knut. Thank you so much for joining us.
Thank you for having me.
We will kick off this conversation by asking a question that might not be obvious, but is absolutely significant for this topic. And I will go to Paul. Paul, you have wrote recently about the difficulty of defining sensitive data. What is sensitive data? What are the main challenges with this? And why is this difficulty relevant, especially in the context of being able to protect vulnerable groups? If you could perhaps give us an overview of your research here.
Yes, thank you very much. Just to clarify, right at the beginning before I continue, what I'm about to speak about was part of a paper I co-authored with my colleague Jean-Claudio, who I also see here, Jean-Claudio Malgeri. So the ideas are mine and his. I don't want to take credit for something that it is also. But yes, to continue, well, my background, I've also worked a lot in health data, primarily on EU projects, and obviously that's sensitive data. So a lot of my day-to-day work has been advising people on how to use sensitive data. And I've noticed there have been many changes since I started working in this area. And a lot of this is due to the different nature of the data ecosystem that we have nowadays. Big data, connectivity, these have all changed things. When I started working in this area, we were dealing a lot with patient dossiers, isolated kind of data. Now we're talking about big data, connected ecosystems of data. It's a different game. And this has really changed what sensitive data is for us working in this context. And it's really provoking the question, what is sensitive data actually? Firstly, we found it very interesting to compare the discussion about what is sensitive data and how do you define sensitive data to the discussion about what is personal data and how do you define personal data. The latter has been discussed extensively. There is endless literature about concepts such as anonymization and pseudonymization. Everybody is well versed. But if you look in the literature about how should we define sensitive data as a general concept, there is a lot less discussion, which I find interesting because of the importance of sensitive data and its role within the GDPR. And what are we seeing? Well, in the directive and the GDPR, primarily a context-based approach is used. What do I mean by a context-based approach? Well, I mean that it's not the intention of the data controller to determine sensitivity, except maybe with biometric data. But for the other forms of sensitive data, it's the intrinsic sensitiveness of the data themselves that determines sensitive data. And this has been outlined in specific areas by the Article 29 Working Party when it refers to things such as health status, that determines whether we're speaking of health data or not. To describe it succinctly, anything that gives an indication of your health status can be health data. And if you start to think about in the modern big data world, what can give you an indication of health status? That is an extraordinarily wide range of data. If you take the data that you can get from your mobile phone, if you take a few elements such as how far you walk every day, how far your calorific consumption, several factors, how much time you spend on social media, you can start to even generate probabilistic conclusions about health status or future health status. And all of these, according to the Article 29, would fall within the definition of health data. And in the world of big data, this is very remarkable, because what it essentially means is that if you take many large big data sets, they will contain forms of health data or other sensitive data, even where it's not intuitively obvious. And why is this? There are three main reasons: increasing computing power, AI, of course. This opens the door to increasingly powerful forms of analysis, and also the increasing world of interconnectivity, where there is other forms of potentially complementary data available. All these things mean that it's becoming more and more possible to draw sensitive conclusions from data that is not intuitively sensitive at all. It's just the bigness of the big data and the ability to crunch it that can allow this. And so as time has gone on, it seems to us that the scope of sensitive data is actually widening in an extraordinarily wide and fast manner. So much as so that the what is not sensitive data now may be sensitive data in a few years. What was not sensitive data a few years ago may need to be considered sensitive data now. And the ability to intuitively know when something is sensitive or not is arguably decreasing. Because of AI and other forms of analysis, it's becoming increasingly difficult for potential data controllers to know just by their own intuition whether they're dealing with sensitive data or not. And this is likely to, in our opinion, lead to some challenges going forward. If the proportion of personal data that is sensitive continues to increase and increase, we are concerned about several potential problems. One of them is a concept we call the inflation of the concept. So that if sensitive data is used more and more as a concept, that its worth will be somehow less. That if a larger proportion of data becomes sensitive data, then the impact of stuff like DPIAs may arguably become less. If you have to do them all the time, will they become more of a tick box exercise, that sort of thing? And will the concept of sensitive data with time become undermined if it becomes too all present, too everywhere. Another potential problem is that data controllers will be processing it not knowing they are processing it, where it's not intuitively sensitive. And this leads, this raises the concern that harms could be produced either connected to the processing in question, or perhaps through later reuse of the data or the conclusions that were generated with it. We all know that sensitive data is sensitive because it is linked to a potential increase in harms or potential harms related to discrimination, stigmatization, and that sort. And there's another possibility that data processors and controllers may attempt to somehow circumvent sensitive data, may attempt to use proxies, that sort of thing, in order to evade the increasing likelihood that they will be using sensitive data and subjected to the higher burdens of the GDPR. So in short, we propose that we should shift from primarily context understanding of what sensitive data is to a definition that might also employ a bit more of a purpose-based understanding of what's sensitive data. The question is, how do you strike the balance? And we came to the conclusion that essentially, first you should look at data in order to see if it's reasonably likely that it's sensitive. If the question is yes, then you know you're dealing with sensitive data. If the answer is no, then you should also ask the question, is there an intention to draw sensitive conclusions from the data? And we call this a kind of a hybrid way of understanding sensitive data. And we feel that using such a form would reduce the likelihood of the kind of harms that I just described. And that's a very succinct description of what we discussed in our paper, but I hope it's intelligible.
Thank you very much, Paul. Actually, it's more than intelligible, and it's absolutely needed at this point in time, because there are so many laws that are being adopted around the world and that propose sets of sensitive data. And it's very interesting to actually look a bit at how they define it. We've been talking a lot about health data and for good reasons, but other categories of sensitive data generally constructed as such in the GDPR and other regulations are data related to race, ethnic origins, data related to sexual orientation. So they also define vulnerable populations. In recent bills, I've seen other types of data that are very interesting and defined as sensitive. For example, in India, in the proposed General Data Protection Bill, caste is actually a category of sensitive data. And in the Washington Privacy Act, which is being discussed in Washington State, around Seattle, immigration status is considered sensitive data for obvious, American cultural reasons. I will go now to Hengshu. I know that you have done a great deal of work studying privacy and health disparity research. And one of the issues you addressed in your work was that privacy protections, including new privacy enhancing techniques like differential privacy, sometimes mask inequalities in health research because they may hide the presence of individuals. And I was mentioning previously that race, ethnic origins, sexual orientation are categories of sensitive data. Can you tell us about this work and what do you think are the consequences on health research of these techniques?
Thank you so much. Thank you for the opportunity to be here to share some of our latest research results. And I am a privacy researcher by training. The reason why I was get involved into the the health disparity research was a few years ago, I was invited to talk to a group of health disparity researchers and to talk about the implication of data privacy protections. And around that time, when I got the invitation, intuitively, I thought, yeah, I can do this talk, although I know nothing about health disparity. Because, you know, we all know the trade-off between, you know, privacy and utility, right? If we narrow the term utility to disparity, health disparity detection, I mean, intuitively speaking, the same trade-off would be applied. So I actually drafted my talk around the theme about privacy utility trade-off. And then I started talking about, you know, health disparities, or we all know that the health differences we observe between different groups, and these groups can be differentiated by sensitive identifiers such as race, gender, geolocation, income, and education, and so on. And right before my talk, and our team got access to a large data set on patient care in one of the largest states in the United States. So right before my talk, and I was talking to my collaborators to say, well, my intuition of privacy utility trade-off would be applied in the health disparity detection context. Can we quickly show some results? So we choose, around that time, we picked two most popular data anonymization techniques, which are key anonymity and differential privacy. So apply these two most popular data anonymization techniques to this large data set we got access to. And our results, quick results, confirm that these techniques actually mask important identifiers more for minority population, which makes the task of detecting health disparity more difficult, right? Imagine that, you know, due to the health privacy concerns, if the privacy researchers only get the data set that has already applied with this data anonymization technique, right, then their task about detecting health disparity would be very challenging. So initially I thought, okay, this is a well-known trade-off, right, which is fall into the big umbrella of privacy utility, and privacy and the health disparity is also one of the most important utility functions for the health researchers. And later on, some of the latest research on differential privacy in the context of health disparity also confirmed some of our observations and empirical findings we presented like 3 years ago. And one of the recent paper published in the 2020 demonstrate that the noise inserted to the population counts for achieving differential privacy for the purposes of data protection could reduce the accuracy of mortality rates calculated based on such counts, which in turn could affect the health researchers' understanding of the health disparities across different racial groups. So all these studies demonstrate that the data anonymization techniques induced either noise or errors could alter the latest data discoveries, such as the outcomes of disparity detection. In our research, in our latest research, right, beyond confirming the privacy utility trade-off, we ask another more nuanced question. Given that we have so many different types of data anonymization techniques on the market, do all these techniques have the exact same impacts on the disparity detection? Does this, privacy utility trade-off applies across different types of data anonymization techniques on the market? Because we want to provide some practitioners-oriented implications, right, for health researchers or for data owners, right, in their decision-making in terms of considering which type of data anonymization they want to apply to their data set and what kind of impact or different impacts will have to the health disparity researchers. So in order to address this question, we first need to launch a literature review, right? A comprehensive literature review about all the possible data anonymization techniques, as well as the definition of disparity. So based on interdisciplinary literature review, we come out a taxonomy about summarize all the possible data anonymization techniques. So there are two common types of data anonymization techniques. One is through data removal. And one of the most popular examples through this category is the key anonymity, which aims to remove the part of data set that could potentially identify an individual. And then the second type of data anonymization mechanism is through noise insertion, right? One of the most popular algorithms and techniques in that context is the differential privacy. where they basically inserts into a data set with some carefully designed noise that block the identification of individual, but meanwhile allow some discovery of certain summary statistics. So these are the two broad categories of all the data anonymization mechanisms. And in terms of disparity, because we are really looking into the statistic aspects of data discovery, so we actually looking into the statistical evidence for detecting disparity. And based on all our literature reviews across from sociology, population research, and legal literature, we noticed that there are two commonly accepted, statistical evidence for disparity. One is disparity through separation, which is grounded in the idea of detecting the separation between the outcome distributions for different subpopulations. And one of the most interesting practice in terms of operationalized detections through the separation was about 2 or 3 standard deviation. So which means that if the practitioners detect there are 2 or 3 standard deviation across the different subpopulation, that's the basis to establish the evidence for disparity. And the second most popular type of disparity measures from the statistical point of view is through variation. What do we mean by disparity through variation? It means that it concentrates on the magnitude of differences between the mean outcomes for different subpopulations. So in summary, the disparity measures from the statistical evidence point of view is either through comparing standard deviation or comparing the mean. And after knowing these 2 different types of data anonymization techniques, and then meanwhile, these 2 different types of evidence for confirming or detecting disparity, we launched a study to examine the interplay between these 2 different mechanisms of data anonymization, together with the different types of disparity detection. And I will skip all the details about how we did that research, but our results, the overall research results, the pattern shows that under the regime of disparity through separation, data removal anonymization techniques tends to produce more false positives, which means that detecting false disparity when none exist than the false negatives. While the noise insertion techniques, such as differential privacy, rarely produces any false positives at all. So that's the overarching research results patterns, which kind of demonstrate the different types of data anonymization technique you apply to your data set would have different types of impact on disparity detection. And the overall kind of policy discussion we want to share with the regulators and policy decision makers is to properly assess the different impacts of privacy protection on different, subpopulations before mandating or incentivizing either privacy protection, or the collection of social determinant information for disparity detection. As we all know that GDPR, somehow my understanding is that incentivized data anonymization. A lot of requirements may not be applied to the anonymized data set. So if business are incentivized, or including a lot of data owners such as healthcare providers are incentivized, right, to opt in for using these data anonymization without carefully considering some more important social outcomes such as disparity detection, then the overall effectiveness of the legislation may become a question mark to some populations. So that's the overall findings of our latest paper.
That is fascinating. Thank you so much. And this has been such an important topic during the COVID-19 pandemic, because studies have shown, for example, that the African-American population, at least here in the US, because these are the studies that I've looked at, has been much more impacted and in a more significant and profound way than other populations. So it's absolutely relevant. And I will now go to Knut to particularly drill down a bit into the research and the cross-border type of research that was absolutely necessary during the COVID-19 crisis. There's literally no more vital time for rapid, collaborative, cross-border, qualitative health research than the middle of this pandemic. And in your role leading privacy efforts of a global pharmaceutical company, you have been at the forefront of this development. What are the main lessons to be learned from this crisis, especially in the context of Europe right now being more and more serious about creating a European data space? Knut.
Thank you very much, Gabriela, for giving me the opportunity to talk about that. Before I do, I want to mirror Paul for a little disclaimer. You introduced me as the chair of the FPR Data Protection Working Group. No longer I am. I used to be. And I'm just saying that because I'm not talking for the pharmaceutical industry in any capacity at the association, although I'm familiar with the views. So yes, indeed, COVID-19, as I think we've all experienced, was a catalyst for many and an accelerator for many developments, also with regard to sort of finding new ways of collaboration. And what we've seen is that the collaboration across borders and between private and public entities have been instrumental in creating insight and ultimately leading to vaccine development and some promising therapeutics. I participated recently in a conference of the Scanbald cluster, which is an innovation network that showcased some of those collaborations. And I think, what I would also like to say that this was in connection with the German presidency of the European Council. And Scanbald, so this network of research institutions, public and private, put out a resolution which I think is very important, as it calls for acceleration of the European data space and highlights certain features that we need to keep in mind. So in order to preserve the flexibility and network nature of academic and public-private research, we need to create some form of legal certainty within Europe. And I think the first panel was testament to the conversation that we need to have in terms of where are the boundaries of self-determination with regard to your health data and societal benefit, and in particular in research, and what's the democratic legitimation. So I don't believe that limiting the right to self-determination in health data is per se anti-democratic, as I understood some of the panelists to say, and maybe I misunderstood. But what it requires is a democratic process, and therefore it's absolutely necessary that member states start to make use of the derogations, but in a coordinated form, and create the necessary legal certainty with regard to health research in Europe. What industry and academia can do is put together a code of conduct. So that's an idea that was floated since the beginning of GDPR, and it has been emphasized now also by the German presidency. And the European research-based pharmaceutical industry is actually working on a code of conduct. As some of the panelists pointed out, it's important that these code of conducts are meaningful in scope, that they are enforceable, that they don't co-regulate, but that they regulate a space that's not been regulated, and meaningful direct behavior. And what we believe, what the industry believes is also important is to have really regulatory oversight. So ideally in the form of a European Health Data Institute that would set quality and interoperability standards, because what we've seen in many of those cross-border collaborations is that interoperability of data sets and quality is really a limiting factor to the utility of the data sets. So we need to have a more coordinated effort here, and that relates to quality and interoperability standards, as I said, but it also relates to educational efforts and building the capabilities within Europe. And this all needs to be anchored in existing initiatives. So for instance, there's a collaboration between Estonia, Finland, Portugal when it comes to e-health records. And rather than starting to build a pan-European standard, a European Health Data Institute should look at best practices and then find approaches to scale them. So that's with regard to the learnings as they were expressed by Scanbold, which I thought was a great conference. May I just respond to the panel before there were certain topics raised, which I think merit response. So one relates to and maybe that's the benefit of talking relatively late in such a symposium. So with regard to consent as a safeguard. So I think it's important to remember the context in which the EDPB has discussed that. So it's in the context of clinical trials. When you conduct a clinical trial, you're subject to a very rigorous regulation. And part of the regulation relates to how you design your trials, because you need to remember that you put in a therapy into a patient that has not proven safety or efficacy. You're about to prove safety and efficacy in the patient. So therefore, you need to adhere to stringent standards. You need to have a protocol. You need to have to run that through medical and ethics advisors, and you need to inform the patients. And here the consent of the patient into the clinical trial is in fact, as was pointed out, an expression of self-determination, but not with regard to informational self-determination, but with regard to the physical integrity, right? You agreed to be subject to an untested drug. Now, as the sponsor of the trial, you need to document the data, and that's not dispositive. The patient can't choose whether to use the data, but you describe your data processing activity, and it's part of the informed consent in the intervention. So therefore, I think it's right to call this consent a safeguard, because it directs, as was pointed out, a safeguard channels behavior, because the consent really describes the behavior with regard to the processing activity. Now, when the consent into the trial is withdrawn, so the informed consent into the intervention, the data set still needs to be with the trial, because otherwise you bias the data set of the trial. So that's not as positive. So I just wanted to make the point. I agree with the distinction. Consent is an expression of the right to self-determination. Here it's just not the self-determination, the informational self-determination, because that's not as positive in the clinical trial. So that's one point to the panel before. And then the second one on data transfers, I absolutely agree. I mean, we need to think about sector-specific adequacy. So the industry has floated that with the Commission for a few years now. In the health data space, it can make a huge difference both for drug safety and for applications like in telemedicine, but also for research. So So sector-specific adequacy, in my view, would absolutely work for the health sector, and also code of conduct would work for data transfers if they would be enforceable. So that's thanks for allowing me to respond to these 2 points.
Absolutely, and this is a testament of how interesting the conversation was in the first panel as well. Just a heads up before moving to the conversation to Elettra. After this first round of interventions, we will be taking questions from the Q&A queue. So please include your questions there, and we're looking forward to address those. So Elettra, I will turn to you now because you are in the unique position here to give us a truly global perspective of the conversation that we've been having. And as I was mentioning at the beginning, you are leading the reform of the OECD guidelines right now. And we would like to know, how is the OECD thinking about the issues that we've just heard about? And again, you know, how important it is to use sensitive data to protect vulnerable populations, the vital role of cross-border research on the basis of health data, but also the difficulty in defining sensitive data. How is the OECD thinking about all of this? What are some of your current initiatives, policy directions you are seeing?
Thank you, Gabriela. I'll address your questions perhaps in reverse order. So linking back with Paul's presentation and then also Knut's, in many ways there, I must say with most of what Paul and Knut said, I would agree with. So getting to the OECD guidelines on the protection of privacy and transporter flows of personal data and on how they handle the issue of sensitive data, that's going to be my the first point. Let me first backtrack slightly for the audience. Just to recall, the OECD privacy guidelines were developed in 1980 to address the twin concern around the threat of privacy from more intensive use of personal data and the risk to the global economy from restrictions on the flow of information. And one of the key challenges described in the 1980 explanatory memorandum, and we're talking now about the original version, the privacy guidelines were revised in 2013, and now we're actually reviewing them. We're not yet at the point of saying that they need to be revised or reformed. Actually, there is a lot of consensus around the principles. So getting back to the 1980 guidelines, there was a tension around how the guidelines needed to address some of the key issues. And a major one of these issues was exactly sensitive data. Others were automated data processing, oversight and sanctions, retention period, and other implementation matters, as well as applicable exceptions. Now, from the records, and if anybody is interested, these records are available online, it appears that in particular, a question arose with the expert group that was following this work, whether the guidelines should be of a general nature or whether they should be structured to deal with different types of data or activities. Now, despite the broad consensus that was reached around the 8 core principles of the guidelines, which have been taken up by practically all privacy legislations across the world, on the very issue of sensitive data, finally the experts agreed, and I must say with great foresight, that it was not possible to identify a set of data which are universally regarded as being sensitive. And it goes somewhat toward what you said, you know, that you might find in India, you would have castes being, you know, considered sensitive, or you might have in other places, even, you know, immigration status to be sensitive. So that was a conclusion. Nonetheless, the guidelines suggest that different protective measures can be applied to different categories of personal data, depending on their nature and the context in which they're collected, stored, processed, or disseminated. In addition, and I'm now, you know, getting closer to us in 2013, and the 2013 version recommends that international transfers should generally be presumed as allowed, taking into account the sensitivity of the data, the purposes, and context of the processing, and any restriction should be proportionate to the risks presented. In other words, the text of the guidelines acknowledges that degree of sensitivity will depend on both context and purpose, and that's exactly what Paul was saying, and emphasizes a risk-based approach to guide practice and to anticipate and mitigate privacy risk. The guidelines also include an enhanced focus, as many probably of you know, on the role of accountability, which is also what has happened with the GDPR, as a means to promote and define organizational responsibility, as well as foster appropriate governance and institutional arrangements. So this concept of a risk-based approach and enhanced accountability has also guided, in many ways, most recent discussions within the OECD on this matter. Now, on the issue of data transfers and access and sharing of data, I think it's quite evident from what we've seen, and actually the discussion in the previous panel too, that the interplay between privacy and data protection on the one hand, and access to and sharing of health data, whether it is for research or public health, presents still a number of challenges. Our work at the OECD confirms that despite the growing evidence of the economic and social benefits, data sharing and reuse remains below its potential in most countries, including for research data transfers across the globe. And I will spend the rest of my few minutes for my remarks on two main points linked to this issue. First, in relation to the interoperability of privacy and data protection frameworks. Now, we've carried out the review through also a survey of our OECD member countries, and results from our ongoing review and the survey of the implementation of the 2013 OECD privacy guidelines indicates that many countries, at least that's the way the countries reported, that the multiplicity of applicable data protection and privacy regimes and the additional conditions and derogations often introduced around the protection of sensitive data, and particularly health data, including the increasing data localization requirements. Because let's not forget that a number of countries are now integrating data localization requirements for health data. This creates uncertainty for governments, businesses, and even researchers, and this has an impact on data transfers. So although, again, our survey indicated that practically all OECD countries today are parties to at least one multilateral agreement or legal framework that defines or overcomes legitimate restrictions on the transfers of data, as Knut just noted, and as has been reported by quite a number of academics recently in peer-reviewed articles, and Science was the last one with Bartha Knoppers from McGill University reporting on this. The uncertainties around the various legal bases for data transfers outside the European Union has stifled research collaborations between the European Union and the rest of the world, resulting, at least from some of the reports, even though this is anecdotal, as we heard in the previous panel, even in the termination or harmful delays of critical data flows, including for biomedical research. And I think that there is increased uncertainty now following the Schrems II decision. But even within the European Union, according to the first evaluation and review of the General Data Protection Regulation, which is available online, there are difficulties within the European Union as member state legislation follows different approaches when implementing derogations from the general prohibition for processing special categories of personal data, including for health and research purposes. So the need to set conditions for enabling greater data access and sharing is paramount, and has been on the OECD agenda now for quite a number of years, and has received an enormous impetus from the G20 discussions, and particularly Japan has led a call for data flows with trust. So this brings me to my last point, and about the fact that privacy is only one side of this equation, and we heard it also in the previous panel. That means we need to look beyond mere legal compliance. And Claire Staunton was very clear about this. I think the appropriate reconciliation of the risks and benefits associated with health data access and sharing is necessary if the interests of both individuals and societies are to be best served. But this requires transparency, an understanding of the reasonable expectation of individuals, the development of a shared view of social contract around how best to serve the public interest in both the protection of health data privacy and in the benefits to individuals and to societies from health data availability. And so a strong takeaway actually from a recent work on COVID-19, and we organized 2 workshops with the Global Privacy Assembly on this, has highlighted the importance of keeping vigilance on public perceptions and also having some clear indicators to assess the effectiveness of the solutions that are being deployed and that require extensive personal data collections. So in many ways, what we think here at the OECD is that at the end, much depends on how we inform the judgments on necessity and proportionality of the data collections, particularly sensitive data collections. I'll end here for the time being. Thank you.
That was fantastic. Thank you so much, Elettra. And before going to the questions that are lined up in the Q&A, I'm wondering whether any of the panelists has a strong desire to react to something of what the other panelists have pointed out to. For example, I'm looking at Paul, maybe you would have something to say about hearing the difficulty of that the OECD is facing right now and has been facing in the past actually, to define personal data in the sensitive data in the guidelines.
Yes, thank you. Yes, we read the guidelines for our research, and they're quite interesting. And it's been interesting to see the evolution of attempts to define sensitive data. The early approaches in the guidelines, which said they couldn't be defined, and then things evolved to a state where in the EU directive, you had defined categories, but member states could add further categories. And now to the regulation, where the categories themselves, as far as I understand, seem to be pretty much closed. I mean, member states, according to Article 9, can add further regulation in relation to genetic, biometric, and health data. But I'm not sure whether they can create new categories of sensitive data. Would you agree with that? I'm asking a question back now.
It's I don't think they can add to the categories either.
Yes.
They can restrict. Who said a yes? Was it you, Paul?
No.
So they can, add conditions, and they have the flexibility to add conditions to what can be done processing sensitive data, special categories of data, but I don't think they can add to those categories.
Yeah, so this rigidity itself might be concerning, especially given the changing world we live in. It's it's difficult to know what categories could be sensitive in 5-10 years' time. And there is also, of course, the issue of different contexts in different parts of Europe.
Absolutely. I'm going now to the questions in the Q&A, and we have a question from Marty Abrams, our friend from the Information Accountability Foundation, and he is asking the panel to explore a bit the notion of risk. He is asking that if we are talking about risk, the question of risk of what? Is it the risk of inappropriate outcomes? Is it the risk to individual self-determination? And when assessing risk, is it only risk to the data subject or risk to other stakeholders as well? And perhaps Elettra or Knut would want to take this question first. Elettra?
Well, what I can say is that in many ways, the issue of, in fact, defining what risk and in assessing risk for privacy has been quite a controversial issue. Because in particular, when we think about the use of data for public benefit and with return to society, I think in many cases we need to think about nearly the the reverse problem, and that is whether or not harm can be caused by not using to data subjects, by not using that data because of lack of accuracy, since we are here in talking about sensitivity and accuracy, and completeness and updating. So there is the reverse, we have to consider both the risk to the individual subject, but also eventually the risk by not using that data to give it to society, or even more broadly to the problem of the quality of the data that, and the accuracy of the data that eventually we will be producing. So the universe of risk is broader than just the risk to the individual data subject when we talk about health data research, use of health data for research. That's at least my consideration here.
Thank you so much.
I would like to second that. So there's a risk in biased data sets, and data sets can be, as we also heard from Heng-Shu, and data sets can be biased in many ways. And one way to bias data sets is to have underrepresented populations. Now, if you think about, if you're relying only on consented data, then you're already biased towards a certain population that would be more inclined to consent. If then you move to things like dynamic consents based on mobile applications, you bias to those who are digitally literate, excluding even more parts of the populations from the data set. So there is a risk, a real outcomes risk to excluding certain populations, and that's a risk to patients themselves, right, and to the data subjects themselves. So I agree. You need to look at both. But when I think about risk to the data subject, to me, it's mainly the risk of being stigmatized, singled out, discriminated against, and I firmly believe that any conversation that we need to have around the use of health data for scientific research, where it's important to have large, unbiased data sets for the benefit of society and individual members of society, has to come with protective measures, so that address that risk specifically. To me, and that's potentially a different set of laws, or maybe in the same. Maybe you could craft it in a health data law.
Heng, how about you? How are you seeing this issue?
Yeah. I like the risk lens of viewing or assessing, right, the privacy. But when we think about risk, in my context, especially in the very super complicated context of health disparity detection, right, we apply data anonymization to the large data set for the purposes of reducing the risk of data breach, right? If think about health data set which contain multiple sensitive data attributes. So that's the reason why the data owners intend to apply data protection techniques to this large data set. But when we apply that also increased the risk of failing to detect health disparity, which will lead to undesirable outcomes to some subpopulations of our society. So it's a very tricky thing when you do this risk-benefit analysis. Traditionally, I mean, without me involving with the health disparity research, I truly believe that data protection in general is a good goal. But when I engage more with the health data set and the health disparity research, I just feel that this, double-sided effect of data anonymization, the unintended consequences about bringing data anonymization to the large data set, which may hurt some subpopulation in terms of, for the consideration of their health benefits or outcomes. So that's really intriguing. And also when we think about doing risk assessment, right, we also need to shift from one data subject lens to a very collective view of subgroups, or based on the education status, race, gender, and so on. So we need really to move beyond the individual level of analysis, right? Looking into each data subject, to different groups, and to the whole society, based on different kind of contexts. I have to admit that health disparity is a very complicated context we're dealing here. The risk might be different when we are comparing with other contexts.
And perhaps this is precisely where a tailored legal framework for research is actually extremely useful. And this is where we can think of specific rules for anonymization and privacy enhancing techniques as not being extremely incentivized for research purposes. But indeed, this is absolutely necessary, a necessary discussion. Concluding remarks, I would like to, perhaps we have just 3 more minutes, but I think one of the very relevant conversations to have is going back to cross-border data flows and the necessary data for health research in the pandemic, and the data localization trends we are seing right now around the world. And I'm looking at Elytra particularly. I'm wondering what should we do to counter the data localization wave that we are seeing sometimes in even regulatory action, but sometimes just a de facto sort of trend to data localization. I know that the OECD is looking into this. Perhaps you can give us a bit of insight.
Well, we've held quite some discussions this past year, and around and prompted actually from a request from the government of Japan based on their action emerging from the G20 on data flows with trust. And we focused significantly on the issue of examining closely data localization and government access to data as 2 major barriers to trust in data flows. We've had significant contributions actually on these discussions from Professor Kuhner and also Professor Dan Svantesson. I must say the OECD privacy guidelines already provide some light, in the sense that the paragraph 18 of the guidelines and the proportionality test that the guidelines suggest in terms of the potential test to justify restrictions to transborder data flows is a way forward, and it is a way that we could consider in examining further with countries and creating codes of conducts around. I think it's creating this level playing field across countries on an understanding of what are legitimate restrictions and what should be this proportionality test that could support these legitimate restrictions. There are more common approaches across countries that one would think, and we're actually working around those. And going back also to something else that you raised in relation, we need more legal certainty and maybe a specific targeted law. Well, I'm not really convinced that that's what we need. We've moved toward governance, and we're moving toward governance frameworks, because it's around governance frameworks that a harmonization is more possible. And at the OECD in 2016, the Council adopted the OECD recommendation on health data governance that sets out the governance framework necessary exactly to achieve this greater harmonization in practices. So I think that working around code of conducts and governance frameworks is perhaps the way to go. There is also, I would say, a great deal of interest now in the Governance Data Act that we just heard in the previous panel, because that's a direction in which I think countries are all going. Creating more norms and more rules might be creating even more complexity and not, let's say, helping achieve what we're trying to achieve here.
Well, thank you so much for that. And I see we're already 1 minute past the top of the hour. This was an incredible conversation. I'm really grateful for your time and for your insights. Thank you so much, panelists. And I hope to hear from you soon on these topics. I will now give the floor to Professor Kunar, who will introduce our closing keynote.
Thank you very much, Gabriela. And I'd like to, first of all, thank very much all of the panelists and the speakers and the moderators. It's been quite an education sitting here listening to you over the last couple of hours. Excellent points, a lot of food for thought, and I think you've very easily attained the high level of discussion that we've had also in previous years in the symposium. So we've shown, I think, that even that COVID cannot beat us, that even with the restrictions we're under, we can still hold an excellent event with excellent content. So now my task is actually very easy, because I have to introduce someone who actually needs no introduction. So it's quite easy. And this is Mr. Wojciech Wiewiórowski, who's of course, as we all know, the European Data Protection Supervisor, was previously the Assistant Supervisor, and before that was the Polish Data Protection Commissioner, so someone with very deep experience in data protection at all levels. And of course, we also know that the EDPS now has a role, a leadership role in data protection that goes beyond its role in supervising the EU institutions, and really is a role that extends globally to all sorts of interesting data protection policy discussions. So perfect person to end our day today, our symposium, with a brief concluding keynote. So Wojciech, thank you very much for making time from your very busy schedule, I know, to speak to us, and the floor is yours.
Thank you very much, Chris. Thank you for the possibility to be here, and for possibility to speak to you. But first of all, for the possibility to listen. That's probably the most important part of the story for today for me. Well, I have to say that I spent last 3 hours here at the computer with short breaks, which were caused by the different things that you had to do for the EDPS, but I decided to devote these 3 hours for the discussion about sorry, I think I'm not visible. Oh, no. Now you can see me, I guess, as well, yes?
Great.
Yes.
Okay.
Yes, we can.
So let me say again that I spent these 3 hours here listening to this discussion and trying to find out all the perspectives which are presented here, and I did it with really a lot of interest, and it opened my eyes to several subjects which probably vanished somewhere from the head of the person who is the regulator, and who are still or were still in my head when I performed the role of the academic, because I come from the academia, I come from the university, I still teach in the university, which makes me open for the kind of punches, both from the side of those who say that the researchers are actually obstacled by the GDPR, but also those who say, what do you do there in Europe, in the European Union institutions, to really help us to fight with those who are abusing our rights? So that one of the things which is quite well visible for me when we are talking about the scientific research is that the questions are coming from all the directions, and the questions may differ depending on which science do we present. While there is a lot of discussion on the in the field of medical sciences and everything which is connected with health, I would say that I still don't see this kind of discussion among the historians. And we have to remember that the modern history is also the history. And the modern history is actually also the processing of the personal data of the people. And here we come to the first question, which is always at the beginning of the discussion about the scientific research, which is, of course, what is the science and what is the research and what is the researcher and who is the researcher, and which is the most difficult, when the researcher is a researcher, because the person who works in the university and who performs the studies as the member of the scientific institution, university or institute or however it is called, is often also playing another roles in the society. The roles which are connected with the fact that he is employer or represents employer, but also his work for the entities which are not exactly the scientific entities and which are commercializing the results of the research, which, by the way, is a good thing, which, by the way, is what the science is for. The science is not for science only, but the science is for making making our life better. So bearing all this in mind and having and concerning the fact that from the very beginning of this mandate of the European Data Protection Supervisor, we were stressing the fact that this solidarity is a part of our point of view to the world. EDPS is trying to be as involved as possible into the discussion about the use of the data for the humankind. I'm always stressing the fact that the General Data Protection Regulation is not only about the protection of the data, but is also on the free data flow. And this is even in the title of this legal act. And we have to remember that we are protecting the personal data in order to allow it to flow, to allow it to work for the good for the humankind. So this is not, we are not protecting the data, we are protecting the human being. And protecting the human being means to use the data in the way that may be productive for us. That is why we finally finished the work which has been started by my predecessor, by Giovanni Buttarelli, on the work on the opinion on scientific research, the one that was presented already today. I know that I was supposed to say more about it during this closing remarks, but since Claire from our office has presented this opinion already during the panel, I think it stopped making sense to say it again. But I would like to say that we are trying to operationalize it a little bit more at the moment. First of all, because of the proposals that are given by the European Commission and which are dealing with, for example, the so-called data spaces, which are also used for these purposes, which made us preparing another preliminary opinion on the use of the data in the e-health systems, also addressing the problem of the use of the data spaces, and also by answering the questions and answering the requests for opinions from the legislators in the work on the Data Governance Act, which has been also discussed here. That is not the right moment today to discuss in details on the proposal from the Commission. First of all, because this is still the new document for most of us, and even for us. We've been asked during the informal consultations before the Commission came with the proposal of the draft, and I have to say that we are extremely critical towards the proposal which landed on the table of the DPS, but this is not the same proposal as the one that was finally adopted by the collegium. So I have to say that I didn't study to the very end the new document which was revealed just a few days ago. But I have to say that the approach of the European Data Protection Supervisor to the idea of data altruism, about the idea of the data holder as the next notion which is in use here, is really cautious. These are the things which sound strange in the legal act, and probably will cause the same problems as those that were that we were talking about for a long time here during this discussion, like the problem of the sensitive data. I'd like to stress that there is no notion of sensitive data anymore in the European Union data protection law, while of course it all starts from the discussion about sensitivity of the data. Now we have different ways of protecting the data. Even this data which is called sensitive is differently protected. There's a different system for those that are mentioned in the Article 9 of the GDPR, different systems for the data coming from the court decisions, the other system for the genetic or biometric data. And as you said very well, that is also sometimes supplemented by the law, the national law in these countries. But anyway, we have some proposal of having the one approach, one organized, harmonized approach in Europe, but the term sensitive data creates the waves, and will be definitely differently understood in different cultures. But once again, let me say, all of us here in this room would say that the data about our financial situation is sensitive, but this is not sensitive data according to the solutions in GDPR. That one, if we can find the sensitive data in GDPR, this is not financial data. At the same time, the information about the religion that the person observes is a sensitive data, while for most of the people in the world, it's not something that they are hiding from the others. Moreover, a lot of people are very proud of the fact that they are the members of this religion, or they are not the members of any religion. So these things, apart from the fact that they depend on the culture, they depend also on the individual approach. And this individual approach also makes us to think that to decide generally that there are the ways of using the data, and there are the parts of the data sets about us that should be that should get the more liberal regulation, is always the dangerous and also always very delicate part. We heard here about the idea of having the how is it, sectoral adequacy as far as the scientific research is concerned, and to decide on the global level probably on the fact that we will agree for this kind of adequacy between the countries. I find this also quite a dangerous idea, but the idea that definitely we should talk about, because that will come back again and again and again. So this discussion shall be going on, and that's why I'm very happy that I was taking part in today's meeting, and I had the opportunity to talk with you about it, and first of all to listen to this discussion. There was an interesting part of the story during this discussion about the diversities. The diversity as the one of the lost part of the discussion about the personal data. meaning how the personal data protection may prevent us from finding out the differences between the groups, and also to defend and to protect the groups of the people, knowing about the disparities, the diversities between them. This is the problem which exists in the science and is very well visible in the science, but it's also visible in the managerial work. We have a lot of discussion about data protection being an obstacle in finding and managing the diversity at the workplace, for example. And I think that would be also interesting to find that there are the common points between the discussion about the labor law approach to the diversity and the scientific researchers approach to the same problem. What I also find as a kind of outcome that somebody said finally once is what Dara said about the codes of conduct, saying that that's a wonderful idea, but just show me the one that works. Yeah, and this is something which I have to admit once again, saying that every data protection authority in the European Union at least, but I hope also in the world, will tell you the codes of conduct are the very good tool to deal with the certain issues connected with data protection, including the transfers to the third countries. But they usually say it because we didn't have the empirical evidence of this kind of code of conduct working on international level. They work on the national level, but on the international level, it's much more difficult. And if we don't treat the OECD guidelines as a code of conduct, because it's not code of conduct, then we can say that we are lacking the good experience. But the problem is not at the data protection authorities who are not allowing to use them, not recognizing the codes of conduct. The problem is that the codes of conduct are still not prepared inside the business and also inside the scientific field, inside the scientific community. And it won't be easy to do that. Believe me, as a person coming from the academia, I precisely know how difficult it is to find the agreement for the code of conduct among the scientists, among the people who, well, have the big expectations towards their own mind and the mind of the people around them. I guess that the discussion about the practicalities would be the next step in trying to find the right way of answering the questions of the scientists and answering the question of those who wants to implement the results of the scientific researchers in the community. And let me finish with what I actually started with, saying that we shouldn't forget the fact that being a scientist and doing the scientific researches is contextual. And it's sometimes very hard to say who is the historian, while it's probably not that difficult to say it when to think about the medical sciences, who is the researcher. In the other ways, in the other fields of science, that might be more difficult. And moreover, we are still talking about the sciences, which are the sciences, and we would all agree with it. But if we go to economics, if you go to the managerial studies, there are the people who say that these are not the sciences at all. So they should not be treated the same way. And on the other hand, why not to use in economical studies the rules which have been prepared generally for the research? And also contextual in the meaning that I speak with you claiming the fact that I'm a scientist, and actually you decided, and I guess also Jules, Chris decided to invite me here and to speak here, not because I'm the scientist, but because I'm the regulator. I'm the official of the European Union. So I'm claiming the fact that I'm the researcher while in fact, you know very well that I present the opinion of the European Data Protection Supervisor, which is not necessarily the same opinion as the same person has as the scientist and the member of the academic community. Well, being the lawyer, I try to manage this schizophrenic situation where there might be different points of views in the same head, but this is something to remember about as well. Scientific activity is contextual, and the use of the legal solutions for these purposes have to take this the context into consideration. Thank you very much. Thank you for all the things which I learned during this discussion here. But also, I would like to invite you to stay in the discussion with the data protection authorities and with the administration as a whole. And not only discussion, but also in the learning mode and in the teaching mode towards those who are representing the states and the international organizations. Thank you very much, Christopher. Back to you.
Thanks so much, Vrije, in your role both as the EDPS and as somebody who wears a lot of hats, because frankly, the data protection regulators today are setting rules and helping set rules that affect every aspect of society. And so it does take people to bring not only a regulatory perspective, but a deep understanding of all the values that are pressing in order to be able to help shape the proportional and necessary balances that are essential. Chris, if you're there, welcome to join me. I think we just want to thank all of you. It's been a long day, and I apologize that it was not a longer day. I think those of you who deeply care about this issue and the evolving debates and thinking around it realize we only scratched the surfaces, and one could have done multiple sessions on almost every one of these fine points, because they are all deep and complicated, and but there's only so many hours that I think we can have people do this virtually. So we will continue. We've got a number of projects on the FPF side that continue in this area, and many of you. So let's all stay in communication. Quick thank you to Gabriela Zanfer-Fortuna at FPF and Gian Claudio Malgieri on the VUB side, who really did so much of the work, not just today, but in the organizing and preparing, with Rob Van Eyck on the FPF team, and with the VUB staff, and Omer Tanay, our senior fellow, who is always invaluable. Thanks Nicole Sanchez and the FPF and VUB back-end teams for making the logistics go relatively smoothly. Thank you for that. Thanks to the participants, the panels, Wojciech for really thoughtful closing remarks, and of course the sponsors who help make these things possible, our colleagues at TomTom and Big ID. Any special notes that the organizers want me to mention? No? Then Chris Kuhner, I thank you and the VUB for another wonderful partnership. Next year will be the 5th, so hopefully we'll be able to be together again and do this in style. And we thank all of you. We had more than 300 at various points, so I think lots of depth and lots of interest. Thanks all, thanks to the teams, and thanks to all of you who joined us.